I'm going to call this meeting to order. Dale, will you lead us in the salute to the flag?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This is a continuation of last week's meeting, so I'm gonna ask both attorneys. We have some people that would like to speak. We went through the open session and we went through the speaker session, and we've come all the way through, and now we're getting to the end. But we do have a request for some people to speak.
We call a roll call.
So I'm sorry, Sherry. I wanted to get that done. Go ahead.
Okay, thank you. Board Member Ulrich. Present. Board Member Hanson.
Present.
Board Vice Chair Farmer.
Here.
Board Member Chair Daddy.
Here.
And Board Member Quillisi.
Here.
Thank you.
So, if I have no objections from either council?
I have no objection.
Okay, Mr. Lowe. Okay. Mr. Shapiro.
Quite an entrance there. Michael Shapiro, 1231 Fairview Court, Ojai. Thank you, Council Chair, Council attorneys from various places, Mr. Stewart. I wanted to just state very briefly that the whole idea and the concept between about Silver and Wright and this sort of interesting legal cottage industry they've created, I really appreciate have been of great value to a lot of cities in California. There are cities that have been transformed from being horribly blighted with dilapidated buildings, homes that were seedy, derelict, who knows, magnet for crack sales and all kinds of crime that have devolved into dangers, real dangers. And the Silver and Wright formula helping cities combat that has apparently worked, if you read their website, and I think they provided a great service. However, by any remote stretch of the imagination, I would implore all of you to understand that the vacant bowling property was not, has never been anything remotely like the buildings that Silver and Wright have successfully transformed on behalf of cities. You just can't compare the two. And this board is surely aware that the owner of the bowling alley property has for many countless years attempted to redevelop the property in good faith. Each time the redevelopment plans were submitted, thousands and thousands of dollars at her expense, they were rejected. The owner has nevertheless continued to find additional developers to transform this lot into something that we could all be proud of. We all hope and want a building that will employ Ojai people, that will be an aesthetic choice that all of us will be proud to have on our main street, something that hopefully perhaps we'll all use and enjoy, both visitors and residents alike. And I think we're at that moment once more, where the latest plan that is going to be going through the city process to determine if that's the one to do. And I think it would be incredibly responsible for the BAB to give some slack and allow this next plan to be fully considered. But for sure, this is not one of those derelict buildings that Silver and Wright law firm is adroit and professional about fixing on behalf of the cities they work for. This is just not one of those. Let's let this building get redeveloped. Thank you.
Thank you, Michael. Next, what? Ms. Ellis?
Good afternoon, Delaney Ellis Labar, 206 South Blanche. For the last 15 years, my husband Doug Labar has managed the bowling alley property, so I've observed secondhand the ups and downs through the years of Ms. Bazana's attempts to either develop or sell the property. To my knowledge, there have been at least 7 proposals brought to the Ojai City Councils over the years. I know she spent tens of thousands of dollars with engineering and architectural firms trying to figure out what is the highest and best use of that property, only to have them all rejected by the city, who wouldn't say what they did want, They only said what they didn't want. And the whole tenor of the city has been so unwelcoming, and I hate to say it, but it feels like this committee is a part of that. But the city has been very unwelcoming of prospective buyers. The development director wouldn't even take a meeting with the CEO of Boku Superfoods, who wanted to locate their world headquarters here. She was so rude that he backed off that. Other prospective buyers have reported that the city has discouraged their interest in buying a so-called troubled property. These 58 code violations that are cited for a locked and secured building that makes no pretense of being fit for occupancy as it is, and that clearly will have to be either completely renovated or demolished. So really, what's the point of these proceedings? The city said that the owner was unresponsive to all their letters about the code violations, and that necessitated the hiring of Silver and Wright. But they were sending the mail to the wrong address. So that's hardly her responsibility or her fault for not responding. Frankly, why didn't they just call Doug if they were having trouble reaching her, or the realtor whose sign was out front? Why further did city representatives threaten to break down the door of the building in order to do an inspection, rather than just have Doug open it with a key, as he had many times before, which ultimately did happen? But, you know, as a citizen, I mean, yeah, I'm his wife, yeah, I'm on the inside of seeing a lot of this happen, but I have to tell you, as a citizen of Ojai, I don't get it. What is this punitive, confrontational approach that the city is taking towards property owners here? This very building appeals board, when I watched on TV last September, was talking about how high could you make the fines, how fast could you create enough debt to get a lien, and further, that you didn't want to get, when somebody asked for the address of the property, well, you didn't want to give that because you didn't want to tip your hand to the owners. And I have to ask myself as a citizen, tip your hand to what? This has begun to really smell like a bait and switch deal, where you deny the owner the ability to sell or develop the property, then you slap big fines on so you can get a lien on the property and use this law firm to take it into receivership. And apparently you have a long list of properties that you're targeting. And so my question is this the end game? Is that we're targeting properties in Ojai, private properties, to go into receivership? Is this like a new revenue stream?
Mrs. Labarge, you've exceeded. Can you?
Sure,
just-
I have
just
one
real
last
quick,
sentence,
please?
and so, if that is not the intent, if the intent is really highest and best use of the property, then I would ask the city to please encourage and not discourage prospective owners who are coming forward with projects. Thank you.
Thank you. Mr. Labarge, would you like to speak? Okay. Mr. Lowe, I want to ask a question.
Sure.
And I want to ask a question to the board and to you attorneys. This is what we got dropped off when we came to our last meeting. 212 pages in one, and this is just about as thick as the other. And we've had an opportunity to look at this now. And by looking at this has raised a lot of questions. So my question is, Mr. Lowe, do you want to proceed? Or would you like to hear what we have to say before you proceed? We may ask you some questions, you may answer them, you may get up there and proceed and answer every one of these questions. So I'm going to ask you what your pleasure is.
Chairman Daddy, I appreciate the fact that the board has heard a lot of things during the last hearing, and I think the property owner had 2+ hours to discuss. I do believe that we should be allowed a certain amount of time, be mindful of all the things that we've submitted and that has already been testified to, but I do feel that there are some points that we do need to be heard upon.
Oh, no, you're absolutely going to be heard. What I'm asking is, would you like the board to bring up some of these questions that we've now discovered by reading these documents that we didn't have before? Or would you like to go ahead and guess what we're going to say, answer them now, and then we bring up our questions? I just want to make sure that you're fine with the process, because I don't want but and rebut and back and forth and back and forth. And
I would be more, I think your approach is a good one. I'd be more than happy to answer or address any of those questions, and anything that we still have to say, then maybe I can do it then, and we can shorten the process as opposed to me trying to guess what you have questions on.
okay, and this is going to be the old business. This is going to be the information that we didn't receive in a timely manner to go through. Okay? So I'm going to, from both sides.
Well, I'd like to,
And you will, and I will reserve, Mr. Silver said you needed 20 minutes, and I will make sure that you have at least 20 minutes.
I just wanted to make a noted on the record that we did submit our information, our brief on a prior date, not dropped it off on today.
No, I understand that. Yours came in Monday, theirs came in Tuesday. Still didn't give us the normal 72 hours that we're accustomed to by getting the documents for all of our proceedings. Okay.
Chair Danny, do you,
Yes.
as I'm understanding from Mr. Lowe, he would like an opportunity to rebut the evidence and testimony that was presented last time. And
Yes.
what Mr. Lowe and Mr. Stewart may present may affect the questions that you're poised to ask.
Right.
So would you instead prefer to let the parties present their cases and rest, and then pose your questions?
I think what I'd like to do for fairness, I'd like to ask Mr. Lowe how he'd like to proceed. If you'd like to present now, if you're ready, please step up, and we'll go ahead and be more than happy to listen. Right?
Okay, I was prepared to present, so maybe I'll present first. And if
Please.
you'd like to interrupt me at any time to ask me questions, we could do it that way too.
I'm sure we'll have some questions as you present.
Okay, thank you.
Thank you.
Once again, thank you very much, Chairman Daddy and honorable members of the board. Boy, once again, we've heard a lot of things go on during the prior hearing, and I'm sure what's going to go on here today. And the property owner and his representatives have, made a lot of representations about the property, but I think a lot of those are trying to distract you. It's throwing a lot of things here and a lot of things there about process and notice and all that. And I think I've been able to distill it down after the last few days. It's really about 5 key issues we're talking about here. And the points I want to make are the first one is, back to the original point, and we noted it on the brief, and we'll keep it short, that the role of the board is not to determine the validity of the health and safety code. It's a fact determination board. And the appellant is trying to challenge the legality and the standards provided for in the health and safety code. And they want the board to rule on that. But that's not the board's intention. You're a body that's made up not to make legal determinations, but factual ones. Hey, the attorneys here aren't even allowed to make legal determinations of things. That's the role of the court and the judges. And we've all said this before, that this case will likely end up before a judge. So any arguments or any issues that the property owner may have about the legality of it, it's going to be before a judge that at that time the judge or the court can rule on. So that was my first point. My second point is, okay, you're saying, Mr. Lowe, I understand your legality points, but we disagree with it. That's fine. We can argue the legalities of this case. We can substantiate each one of those. The property owner, through their attorney, has said, hey, you're bringing this health and safety code under or bringing this notice and order under the health and safety code. And the health and safety code doesn't apply to anything that's a commercial property. Well, we're in agreement. There's no doubt that bowling alley was intended for a commercial property. But there's a lot of structures that are used for human habitation that weren't intended for that purposes. We've dealt with cases involving public storage units, people living in public storage units. Whereas a public storage unit is meant for human habitation? No, but people have lived in there. Empty shipping storage containers, those were not intended for human habitation, but people have lived in those. It's the same thing here. We're not arguing that the original intention of the commercial for the bowling alley was for a bowling alley, But we've had testimony saying that people have habitated there. Mr. Stewart has testified. He saw bedding material that was there. Mr. Labar's own testimony has stated, what did he see? He saw a door that was ajar. He saw beer bottles in there. Mr. Stewart said that he saw toilets filled with feces, which we produced photos of. Animals don't use toilets. So there's clear indication that the structure was being used for human habitation purposes. There was not a situation where you had, the Health and Safety Code doesn't say how long it has to be habitated for. It just says human habitation. So we have a situation where we've proven that point where the Health and Safety Code applies in this situation. The next point I want to make, and this point number 3, is that the appellant has argued all these procedural flaws. The city didn't do this. The city failed to do this. The notice and order was improperly issued under the vacant building ordinance. Number 2, the notice and order didn't provide a clear direction of how to conduct the repairs. And then on top of that, the appeals was improperly denied. But what does all this have to do? What does this issue have to do with? It has to deal with due process. What is due process? There's 2 elements to due process. One is notice, and one is the ability to be heard. What does the notice and order provide? It provides notice. And what does the opportunity to be heard is? He's arguing about the denial of appeals. We are at the appeals. They're being heard. Regardless of that, if we end up in Superior Court, they're going to have another opportunity to be heard. So they are satisfying the due process arguments here. Back to my point about the notice and order. The notice and order is not brought under the vacant building ordinance. If you take a look at what we produced in our exhibits, there is, in our brief, we have as Exhibit A, if you take a look at our brief, in 2014, the city did issue, October 8th, 2014, the city issued under the City of Ojai, vacant property maintenance, security, and registration abatement plan. This is the notice that the city brought under the vacant building ordinance. This is what they were arguing that the notice and order failed to do. I'm going to draw your attention to Exhibit C, which is part of the photos and everything, which was issued December 11th, which is the whole entirety of the focus of this appeals board. It says notice in order to abate, repair, or abate. These clearly cannot be misconstrued or be construed as the same document. They're clearly 2 separate documents. The vacant building ordinance was issued under the Ojai Municipal Code, as it states here. Chapter 15, Title 9 of the Ojai Municipal Code. The notice and order to repair or abate brought under Health and Safety Code 17980, it's ETSEC. These are clearly 2 separate documents, okay? On top of that, even if you make an argument, or they're going to try to make an argument, they have, saying that the notice and order was a vacant building ordinance, or brought under the vacant building ordinance, and you failed to comply. Well, even looking at that, even if you assume that the notice and order was vacant building ordinance, what does the vacant building ordinance require? Requires notice, okay? The city clearly provided notice. We'll go through it in a little bit when I follow up with Mr. Stewart. But Mr. Hopstone liked to go through the notice, and he picked number 2 and number 3, maybe number 15, saying, wow, you didn't specifically tell us how to repair this. But as we'll go through it, each one of those items, maybe save for a handful, didn't explicitly say how to repair each and every item of those problems. And number 3, there's a 90-day requirement for, or 90-day notice period to comply. Since the notice and order was issued on December 11, 2015, to today's date, or to the initial hearing date, we've had 100+ days to repair. So far, other than producing maybe some photos of some sweeping that was done, what compliance has been done? And regardless of that, let's say you said, oh, they did other things to comply. If we look back to the original vacant building ordinance that was issued in 2014, they cited it, they read it, they were talking about overgrown or dead vegetation. Okay, well, there's still dead palm fronds on the property. Next one is chain link fence with barbed wire around property, which they've asked them to remove. It's a year and a half, and they still haven't even complied with 2 of the 3 on the vacant building ordinance. So what other notices can we provide them that they have failed to comply with? Also, in talking about my original point about the notice and order, in the introductory statements by my partner, Mr. Silver, he stated that the city has a lot of tools in its toolbox. Even Mr. Hopstone raised that. We're absolutely in agreement there. There are a multitude of options that the city has available. They are not limited to only bringing something under the vacant building orders. They're not limited to only bringing something under a notice and order. They can bring any of these, or all of these, or even more options. As cited by the Ojai Municipal Code, Title 5, Chapter 6 of the Ojai Municipal Code, Section 5-6.10. The procedure is not exclusive, and I'll read it verbatim. The procedures provided in this chapter shall be cumulative and in addition to any other procedures provided by the laws of the city or the state for the abatement of any of the conditions described in this chapter, and abatement pursuant to the provisions of this chapter shall not prejudice or affect any other action, civil or criminal, for the maintenance of any such action. What does that mean? That means the city has a lot of tools. They can use a screwdriver, they can use a hammer, they can use a saw. The city decided in 2014 to use a screwdriver, which is the vacant building ordinance. In 2015, it decided to use a hammer, which is the notice and order. There's not an exclusive remedy. Also, you've heard a lot of things by the property owner, Mr. Hopstone, about some tax lien that was allegedly recorded, some assessment that was allegedly recorded. There was none of that was recorded on the property. Okay, that is a falsity. The true thing that was recorded on it was the notice and order. That was actually recorded. And you're wondering, well, why is the city recording a notice and order on the property? Well, first of all, under the Health and Safety Code, it's required. It's law that you record that. And you're asking, well, why does the state legislature care about the recording of the notice and order? It's to protect unsuspecting purchasers, future purchasers who want to go in and go, wow, I want to buy this property, and go in and go and purchase it. They're put on actual notice when they go and do that. What happens when you buy property? They run a title search going, wait a second, there's something recorded that's clouding title on this thing. And the reason why is filed under the Health and Safety Code to give prospective purchasers notice that there are nuisance conditions existing at the property. It's for the protection of the public, which is the exact point of the Health and Safety Code. I'm going to ask Mr. Stewart. Mr. Stewart, to your best of your knowledge, has a tax lien or assessment been recorded or filed against this particular property by the city?
No.
Okay. And furthering to that point, when my law firm was contacted by Mr. Hopstone on behalf of the property owners to about this recording of the notice and order, the city withdrew it. And the city withdrew it for 2 reasons. The city withdrew it because the property owners threatened to sue the city, and on top of that, the city was trying to assist the property owner into coming into compliance. So they withdrew it. So that's even a non-issue at this point. So there's no tax lien that's been filed. There's no assessment that's been filed. And there's not even a recorded notice and order that's been filed on the property. My fourth point is that the appellant has claimed a multitude of conflicting statements about the status of the property. If you go through their brief, which I'm sure you have by now, appellants went through it systematically, saying that this issue doesn't exist. Oh, this issue's overblown. I don't know what the city's talking about with that issue. But during the testimony that was given last week, Mr. Hopstone, their attorney, even admits that there's no doubt that this property is distressed. Their alleged expert, a civil engineer, Mark Baker, states that the condition of the property as it stands doesn't meet current building standards. He even goes far as to say that, hey, there's a portion of the back property which is structurally, there's some things that may fall. But you know what? It's okay. Don't worry about it. If it falls, it'll fall into adjacent neighbor's backyard. Wow, I don't know about you. I have little kids. My little kids play in my backyard. I have parties in my backyard. I would hate that if something from an adjacent building that was dilapidated would fall on them. So I don't think that's a point that should be well taken. Also, drawing to the point of Mr. Baker, the alleged expert, he is a civil engineer. He's not a structural engineer, although he likes to say that his company does structural engineering. He's not a general contractor. He's not a code enforcement expert. You know who is the true expert on the issues that we've noted here? It's Mr. Stewart. Mr. Stewart is the building official. He's a code expert. And you know what? He doesn't have any financial incentive in this property. Unlike the property owners and their alleged representatives, he has no financial incentive in this. And Chairman Daddy, I'd like to follow up with some issues that Mr. Stewart had as a follow-up. Mr. Stewart, have you had an opportunity to review Mr. Baker's report, and you had an opportunity to obviously hear his testimony, is that correct?
That's correct.
Okay. And after reviewing the reports, do you have some opinions about that?
After reviewing the reports, hearing Mr. Baker's and Mr. Labarge's testimony, I am more concerned about the structural integrity of the building than I was before.
Okay, and why is that?
The investigation from Mr. Baker left out a lot of aspects of structural analysis that I would have thought would have been conducted by a full investigation of the building. And the sheathing deflection, as described by Mr. Labar, was more excessive than I had originally anticipated, and thereby making me more concerned about the structural integrity of the roof system.
Okay, and do you believe in reviewing the report that it was a full and complete analysis of the structure, of the conditions of the property?
No, I didn't see any indication that they did any analysis of testing of the material to see if there was decay. I saw no evidence that they removed any roof covering to verify diaphragm transfers, if applicable, to the exterior walls. I saw no evidence that any investigation was done of the roof sheathing.
There were certain statements that were made by the property owner and the representatives about you not going on the roof. Did you actually go on the roof?
Yes, I did go on the roof. I did a complete inspection of the entire roof and the structure underneath the temporary roof structure. I did not go on top of the temporary roof because after my review underneath that structure, I felt it was unsafe and it would be dangerous for me to go up on that roof.
Also, Mr. Baker has stated during his testimony that if you look at the photos, they're only small little sections of photos, and it doesn't accurately depict the entire condition of the property. Do you believe that to be true?
No, we have a full set of the building photos, which represented in the information given to the board is just a representation of that.
Okay, and did you alter the photos in any way?
No, sir.
Okay, because if you did, I'm sure we have bigger problems than that, right?
I did not alter the photos.
Okay, and talking about that, let's go through the notice and order real quick, and I'm going to direct the board's attention to the notice and order and the adjacent photos. If you could flip to number 1. You prepared the notice and order, is that correct?
That is correct.
Okay, and can you describe what the condition for number 1 is?
What we're looking at is a soffitted area that has a stucco under the soffit. A good portion of that over the front door has come down for whatever reason. There's been an attempt to temporarily secure the remainder of the stucco soffit with washers and screws. In my observation of that washers and screws, they were starting to rust, and I was concerned that they may still have failure even with the temporary supports that they put in. Keep in mind that this stucco in this configuration weighs around 10 pounds per square foot, and if it was to fall, it could hurt somebody.
Okay. Does item number 1 describe to the property owner how to repair that?
It gives a statement to repair the overhang. It does not give a description of how to prepare the overhang. Under a normal protocol, the engineer or the contractor would submit details to the city on how they would like to go about and repair that overhang, and then the city would review that in compliance with the applicable codes, and then either approve that or write corrections.
Okay, did the city receive any request for repairing that overhang?
No.
Okay. We'll move on to number 2. Lack of running water. Can you describe what you saw there, that you noted that as a condition?
I did not observe any plumbing fixtures that had hot and cold running water.
Okay, and what would be the repair for lack of running water?
An investigation by a licensed plumber would go through and find out why the water is not working and take the appropriate correction action.
I'm sorry, and conversely, it would be if it was a lack of running water, you'd probably want to turn the water back on, correct?
That would be, if they didn't have any leaks and all those were taken care of, yes.
Okay, and we'll flip to number 3.
Mr. Lowe, I'm not really sure. Are we going to go through all 58?
I was going to defer to you, Chairman, because I wanted to make sure that we wanted to know.
And I have no problem. Everybody's going to get as much time as they want. But I'm going to reserve the right to interject and ask a question.
Sure.
And so my question is going to be, when you have a vacant building that needs a build-out or whatever it needs and is not ready for occupancy, my understanding was, and I wished our other city attorney was here, was that there was a ruling that these things not be ready for occupancy in our code. My understanding was it didn't have to be ready for immediate occupancy. And if it's not ready for immediate occupancy, I am questioning the hot and cold running water and where that fits in. I am concerned that no one in this room went ahead and got a fire sprinkler test. No one in this room made sure that the gauge was right and that the sprinklers are right, neither side. I mean, both sides could have done that for the health and safety of everybody. But if we're going to go ahead through 58 and I'm fine, I need to know with specificity if this is a code violation, where it is, where it derives from, and I really need to know how serious no hot and cold running water for a locked-up building is.
Well, I think we have 2 parts of that. If you would, I could defer to the reports, which do delineate each of the code violations that are noted with the photographs, and for the vast majority of them, how to repair that. That was to contradict statements by Mr. Hopstone saying that there was a failure to provide details on how to repair that. So that was my point. So if the board is satisfied with any questions they have for a specific one, they can flip to that one and see what the issue is, what the photograph of the condition is, and how to repair it. Then I will defer, and we won't have to go through all 58 of them.
That's okay. What I want to know now is what is the necessity?
For specifically
Because
for
the building next to me and the building next to that and the building next to that, where I have my offices, don't have hot and cold running water because it leads to less pipes breaking and flooding and further deterioration and problems. So I'm unaware if there's a code section about having to have it after the modification by our city attorney.
I think there's 2 issues there. I think the lack of water is the concern of not having a sprinkler system that is mobilized in case there is a fire that's there. The other issue is that for it to be an occupied building, you would obviously have to have water, hot and water utilization at the facility. So I think that as the issue, what we're talking about now. If you provided me with when that date of when the ruling or the city attorney provided that notice, I could maybe assist in a little bit.
Oh, I just don't want to separate, I don't want to get
Yeah.
too far off in the weeds, so I'm uncomfortable with the fact that hot and cold running water is like a substantial issue, where we have a gauge. Again, fire sprinklers should have been tested, but water runs to the building is my assumption, unless what I'm really asking, do we or don't we actually have water, and did the city find out if we actually had water and if the sprinklers were actually charged? Do we know that?
Chair Daddy, maybe I can give you some insight there. In regards to the hot and cold running water, that's really a code section under the Health and Safety Code for people habitating in that building. So whether a building is vacant or not, if it was being occupied, that would be a normal requirement. In regards to the fire suppression system, I contacted the county fire department, which regulates that. My understanding is they were going to make contact with the property manager to see what the current status was of the fire protection system. I've not heard a final report back from the county fire in regards to what they found or didn't find.
And actually, we put a notice out to everybody to come and inspect. I read that. Did you get any responses back from any of the agencies that had oversight in this matter?
There again, I only had verbal contact with county fire in that regard, and I just indicated the status of that.
Okay, thank you.
Mr. Stewart, if I may get a clarification from you. Are you saying that hot and cold running water are required for this building pursuant to the Health and Safety Code?
That is correct if we're looking at this as being a habitable building.
Well, I'm looking at 17920.3, which is referenced a number of times in the notice and order. And subpart A4 states a lack of hot and cold running water to plumbing fixtures in a hotel. Subpart 5 says lack of hot and cold running water to plumbing fixtures in a dwelling unit. So is it your position this building falls under in either category of a hotel or a dwelling unit?
My point is that we saw evidence of people apparently residing in that, and under Health and Safety Code, that would be a requirement.
So
I'm going to interrupt for just a second. Mr. Rosenblatt, since you weren't part of our roll call, would you please state your name, identify yourself for the community, and explain what your role is sitting up here with us today?
Certainly. My name is Stephen Rosenblatt. I'm special counsel to the board. I'm here to represent the board and assist it in the course of this hearing.
Thank you. Thank you. Please proceed with your questions.
So you're indicating that if, and Mr. Lowe references this in his brief, that there was bedding, and there was testimony to the effect of bedding, there were beer bottles, there was waste in a toilet, and these are indicators that people were in there, correct?
Correct.
Okay, and, well, but there's also testimony by Mr. Hobstone that workers went in there, some to deal with asbestos, others to do repairs and cleanup. Could those persons have left beer cans there?
It's a possibility.
Could they
yes.
have used the toilet?
It's a possibility, yes.
And perhaps someone left an article of clothing or bedding there. So did you, when you went there on November 3, were there any transients in there?
No.
Has the sheriff's department ever arrested people for being in that building?
They have had calls, but as far as I know, they've never arrested for anybody being inside the building.
All right, so what then is the basis, what criteria are you using to take a building that was built as a commercial structure where there's no evidence that the owner has allowed people, given permission for people to sleep and eat and reside in that building? So what criteria are you using to trigger the application of the state housing law to this building?
Once again, I think.
Mr. Law, respectfully, this is the expert. This is the gentleman that signed the notice and order, and he's charged with enforcing all the codes in Title IX, Chapter 1, and the state housing law. So this is really a determination that I understand he made as stated in the notice and order.
Once again, I appreciate that, and obviously Mr. Stewart can testify to his opinion and belief. However, I think we're losing sight of the track of the issues for the health and safety code. The standard isn't how long or if you have proof of human habitation there. It's that there's human habitation occurring, be it for a day, 2 days, 2 weeks, 2 years. And also, the citation for the the health and safety code isn't the only citation that's noted. There's other code sections that are implicated there. And, you know, the issues that are discussed here, even if it's the lack of running water, it's one of 58 issues that we're talking about. If there was water there or not water there, the main issue is that he was unable to determine or confirm that there was lack of, or there was running water at the location. What is that issue? It shouldn't be a human habitation issue. It is for the health and safety code in terms of if you want to make a building habitable, you have to have hot and cold running water. But the main issue is there was no fire. If you don't have water, there's no fire suppression system. If that building caught on a fire, the adjacent homes would be endangered. That's the issue.
Mr. Lowe, determination number 2 in the notice and order cites a lack of hot and cold running water. This is a determination the building official made. He invoked, in part, section 17920.3 of the state housing law, which, as you know, is part of the health and safety code. So isn't it a critical question in terms of what criteria did he use to invoke that code for this building?
Sure, and I think he testified to it that he believed there's human habitation occurring on this building.
Okay, and that's based on signs of someone being in there, but that might have been someone other than a transient or a trespasser.
It could have been signs of anything that are in there.
All right, so let me ask you this. Is the permissiveness of the entry a factor at all? For example, if someone, let's say on a Friday night, City Hall is closed, someone breaks into this building, sleeps here, and takes up, a short-term stay in this building while no one is around, does that mean this building is subject to the state housing law?
Yes.
Even though that was a trespass?
Yes. That's the point of the health and safety code, is to protect the community. The health and safety code doesn't say that. There's nowhere in the health and safety code that says upon permission of a particular property owner. It just says habitation, human habitation. That's the only requirement that's required to trigger the health and safety code.
Well, that's respectfully, that's argument. What's your case authority or statutory authority for applying the state housing law to a commercial building?
The health and safety code provides it on its face, human habitation. It does not make a distinction between a commercial property or in terms of, it says human habitation. It doesn't say how long human habitation has to occur.
This is argument. What's your authority?
I can, if you give me a few minutes, I can look it up.
Well, let's go to the expert in the room.
Okay?
Mr. Stewart, section 179, actually, let me back up. Let me make something clear first. Is the state housing law enforced in Ojai?
Yes.
And did it take an act of the city council to adopt the state housing law for it to be enforced?
No.
And your department is specifically charged with enforcing the state housing law in Ojai, is that correct?
That's correct.
And are you familiar with section 17960 of the state housing law?
Not by number.
Let's see, maybe I have a copy for you. Does that refresh your recollection?
Absolutely, very familiar with that section.
All right, so this is a section that mandates that your department enforces the state housing law in Ojai, correct?
That's correct.
Okay, so if we turn to the last line of that statute, it specifically refers to apartment houses, hotels, or dwellings.
Yes.
Was this building built as any one of these items?
In our observation, the building was being used as a dwelling unit for whatever amount of time that it was being used as a dwelling unit.
All right, let's turn to the title of Division 13 of the State Health and Safety Code. Correct? The title is housing. So is it your position this building constitutes housing?
It was used as a housing unit, in my opinion.
And similarly, is it your position that this building was used for human habitation?
Yes.
Yet all the indicators that you base it on could have been put there by people that entered the building to make repairs.
That's a
Does
possibility,
that change your
yes.
thinking about this conclusion?
No.
Okay. So the title of the act, the state housing law, is called State Housing Law. What meaning do you give the word housing?
It's a shelter used for housing individuals for the purpose of living, sleeping, cooking, and, I say sleeping?
So we can see that 17960 references apartment houses, hotels, or dwellings. Let's take a look at 17950. And that's in Chapter 4 of the State Housing Law, Application and Scope. So I'll read this for the benefit of the board. The provisions of this part, the building standards published in the State Building Standards Code, or other rules and regulations promulgated pursuant to the provisions of this part, which relate to apartment houses, hotels, motels, dwellings, and buildings and structures accessory thereto, apply in all parts of the state. Doesn't this indicate that the state is showing its intention to all building departments in terms of how they apply the state housing law and to what structures they do so?
I would agree with that statement, but in this particular case, we have reason to believe that for a period of time, the building was being used to house individuals in it.
How much time?
I don't know.
And you're making that your conclusion on the basis of an inspection that you made on November 3, 2015.
That's correct.
Do you have any idea of how long the bedding was there and the beer cans were there and the waste was in the toilet?
No, sir.
Okay.
May I interrupt for a moment? Is there any reason to believe that that condition exists today?
I have not inspected the building since that November date, Councilman Daddy, so I do not know.
Thank you.
Now, in terms of, I come back to criteria, right? Well, I should put the question to you. Do you have criteria established for when you decide whether the state housing law applies to a building?
The code sections that you've just cited is what I would use as the basis of making that determination.
okay? Now, the owner would have us believe, have this board believe, that entries that may have occurred in that building were not consented to, certainly by trespassers or transients. In that regard, if that's in fact the case, the owner was a victim of someone's wrongful actions. And let's distinguish this scenario from another one. Let's say we had an owner, maybe of the same type of building, who said, you know, I've got an empty building. I sure could make some money out of this building, so I'm going to start renting it to people and invite them to stay there and collect rent, and there's a bathroom in there, and they can put some cots in there and do whatever they wish to start living in the building. So in that instance, we have, you know, affirmative actions by an owner giving consent to people to enter. In this instance, there's no evidence that these entries by these transients or trespassers were consented to by the owner. Is that a factor in the criteria you use to apply the state housing law to a commercial building?
No, it's not a factor, but I would say that that I don't believe they intended to have people housed in there, although during our initial inspection, there was a back door that was not properly secured.
And what does that signify in terms of habitation?
It indicated to me that the possibility of somebody going in there and using it as a habitable space could have occurred.
Well, isn't that risk present today? Couldn't someone break in the building today and throw a cot down, sleep there?
Yes.
So every building's at risk for that type of entry, isn't it?
Yes.
So your position is that if someone should go in a commercial building and put some bedding down and have a beverage and use the bathroom, that invokes the state housing law?
Why don't I try to describe it this way? If we would have made an inspection of that building on November 1st, and we would have not seen feces in the toilet, if we would have not seen some type of bedding material and empty beer bottles in that building, I would have had a different opinion in regards to this notice and order.
So with the same facts, you would apply the state housing law to an office building, to a church, to a city hall building?
If I did an inspection of a vacant building similar to this, and I did not find any evidence of that building of a possible case where somebody was living in there, I would have a different opinion.
Is the vacancy of the building a factor in this?
No, what we discovered during the inspection is the factor.
I just want to be clear. Someone breaks into a building, vacant or not, and uses it without permission, and you see the same things in that building that you see in the one that this owner has, that's cause for you to trigger the state housing law.
Yes, but the hope would be is that if we was brought to the building departments and knowledge that this was the case, we would have wrote a correction notice to have this cleaned up or abated. And under normal circumstances, under a normal owner, they would have normally gone in and abated that and not make it a health and safety violation ongoing. And that's the difference.
What's abnormal here? I'm not clear on that.
This substandard building has been in existence for a number of years, and we have not had cooperation from the property owner to abate and clean it up.
So that's cause to trigger the state housing law.
No, it's a tool to use to show that it's in violation of the state housing code.
All right.
Would we have issued a notice and order if somebody would have handled this in a expedited manner to get it cleaned up, as the example you gave? No. But if it would have carried on in years later, this still existed, then yes.
So, are there histories of substandard conditions in this property? There's a history, rather,
Yes,
preceding November 3, 2015?
yes.
Okay.
Mr. Rosenblatt, do you have a number of more questions, or?
It's at your pleasure, Chair. I would like to just bring one other section to Mr. Stewart's attention, and you could let me know if I should stop.
Please. Please
Heading
proceed.
17980.6 of the Health and Safety Code. This is in Article 3, Actions and Proceedings. Are you familiar with that?
Yes,
Okay, now this is the section that is the justification for the notice and order. Is that correct?
yes.
And it's part of the state housing law, right?
Yes,
Okay, so let's look at this. In order to issue an order pursuant to this section, you must have found that violations are so extensive and of such a nature that the health and safety of residents is substantially endangered. Who are the residents when you issue this order?
I don't know who the residents were. They were probably transients or people that had gone into the building without permission,
Well,
but they were
that's-
still residents.
Respectfully, that's speculation.
It is.
This section is calling upon you to make a specific finding that the health and safety of residents is substantially endangered.
It's my opinion that it was being used as a residence, and the people that were using it were in peril in regards to health and safety requirements.
Well, let's go back to your toolbox, right? We have a danger, and by the way, I should make this clear. I should question you to confirm this. As a building official, you're charged with protecting lives, correct?
Absolutely.
And in discharging your responsibilities, the residents and the public expect you to be very aware of the risk that a dilapidated building could spontaneously collapse, correct?
Yes,
And you're certainly trying to guard against that tragedy happening, right?
yes,
In fact, that's part of what this appeal is about, right? Protecting people.
that is correct.
Not merely residents, but Mr. Labar, when he goes in the building, workers, right? If a roof or wall spontaneously collapses, someone could get really hurt or die.
That's correct.
But you have tools to address that problem, do you not?
Yes, I do.
Right, so if you go to Chapter 1, Title 9, we can quickly go through the tools, and some of them are covering your notice and order. The Uniform Code for the Abatement of Dangerous Buildings, are you familiar with that code?
Yes,
Do you have the authority under that code to order the repair of a building?
yes,
Do you have the authority under that code to order people out of a building
yes,
and to post an order that no one should enter?
yes,
So that code, and I'll call it the Dangerous Building Code, gave you the tool to protect the public with regard to the concerns you had in this building. Is that correct?
it's one of the tools we could use, yes.
You chose not to invoke that tool, is that correct?
We did quote some sections of the Dangerous Building Code in our list of violations.
I'm now giving you a copy of Chapter 4, at least part of Chapter 4 of the Dangerous Building Code. So are you familiar with Sections 401.1 and 401.2?
Yes.
All right, so they authorize you to issue orders to an owner under the Dangerous Building Code to repair that building or to otherwise make it safe, correct?
That's correct.
Now, did you rely on Sections 401.1 and 401.2 to issue your notice and order?
No. Totally no.
Now, the city building code incorporates the 2013 California Building Code, correct?
The city has opted not to adopt the 2013 California Building Code. We enforce that by state statute.
So the California Building Code is in effect in Ojai without adoption?
That's correct.
Okay. So your notice and order alludes to the fact that there are conditions in the building that render it unsafe under the California Building Code.
Yes.
In fact, by my count, that happened 36 times in the notice and order.
I'll take your word for it.
I'm now giving you a copy of part of the California Building Code. The notice and order cites in section 116.1, unsafe conditions, but if you see under 116.3, you have the authority to issue a notice under the building code to require the repair of the building.
That's correct.
And in your discretion, you elected not to do that.
That's correct.
But you had the tool nonetheless.
Absolutely.
How about the Uniform Housing Code? Does it apply in Ojai?
Yes.
Is there a similarity between the Uniform Housing Code and the section 17920.3 of the state housing law?
Yes.
And in the housing code, is there not a section that entitles you to make an order
Yes.
to repair a building if the housing code applies to that building?
That's correct.
And under the housing code, do you have the authority to order people out?
Yes.
Did you order anyone out of this building?
No. We posted the building as unsafe to go in, but at the time of our inspection, there was nobody inside the building.
Okay. You also cited the building is unsafe pursuant to the 2013 California Fire Code. Is that correct?
Yes.
Are you also the fire official of Ojai?
No.
Do you have the authority to invoke that code if you're not a fire official?
Under state statute, I have the authority as the building official to invoke that code.
Okay. So we're faced with a situation where you saw no cause to use the other tools in the box, so to speak, because you have the discretion to do so, and certainly that's understandable. And yet you chose to invoke the state housing law. Why did you choose that law over, as opposed to the tools that we've just discussed?
Well, I think there's references to a number of the codes within the notice and order. That's just one of the tools we opted to use.
Well, if I may respond to that, the notice and order cites portions of the building code, the fire code, the state housing law with regard to what constitutes a substandard building. But the notice and order only refers to one particular code in terms of the justification to issue an order in the first place. And that's 17980.6 of the state housing law. So why did you invoke that code?
I believe that the way we've indicated that is it and other applicable codes. We could have easily listed all the other code documents in that initial statement, but we chose not to.
So there were no residents on November 3 that you encountered in the building, correct?
In the building at the time of our inspection, no.
So despite that fact, you made a finding that residents are substantially endangered under the state housing law.
Chairman Daddy, I'm going to have to object that Mr. Stewart's answered these same questions from Mr. Rosenblatt numerous times.
Mr. Rosenblatt,
Well,
do you have much more on this track?
well, the reason I'm bringing this up, Chair Daddy, is that, Mr. Lowe, you've made another argument that's rather interesting here. The building official invoked Section 17980.6, which requires a determination that residents are substantially endangered, or the public, and yet you're asserting that the board has no right to entertain the question if that notice was properly invoked.
I made an alternative argument to that I believe that the board doesn't have the right to make a legal determination of that, but I said if the board does find that it does have a legal right, that the building official and the city was justified in issuing these under the notice and order and under state law, and that everything that was done correctly and properly under any legal standard. And on top of that, Mr. Rosenblatt, the statement about residents doesn't just apply to residents of that particular structure. Under City and County of San Francisco versus Gen 2005, 135 Cal App 4305, page 3010, the Health and Safety Code and the Notice and Order protects not only the building and its residents, but residents in the community as well. So any statements that it's only limited to that particular building's residents is not, it's limiting, and it's incorrect under the appellate court's decision. And I would request us to allow me to finish my statements before being basically cross-examined on by special counsel.
Well, just if I may respond, I'm getting to the point of whether the board has the right to consider whether the notice was properly issued under the section stated. The board, does it not have to make a factual finding if there was substantial danger to residents? That's a question of fact. That's not a legal decision. To discharge its duty, the board has to make that determination.
And it's allowed to. I'm not saying that it's not.
Well, you're asserting it has no authority to consider that issue.
No, I'm saying that it doesn't have authority to make a determination if the Health and Safety Code applies in this particular case. And even if the board doesn't believe my argument, that we're saying that under what Mr. Stewart, as the building official for the city of Ojai, he believes that there was human habitation existing at the property.
Hey, let me interject. Yesterday, I made a statement that Mr. Hopstone alleged that those sites, those violations under the state code weren't proper. Mr. Lowe and Mr. Silver, I believe you folks made it a statement that the board didn't have the right to address these because they were state code. What I'm asking you, Mr. Lowe, is do you believe this board has the right, as I understand, that has the oversight and authority over the building official? And when the building official enters these and applies these, that doesn't lessen our oversight over the building official. You may be right about the state law, but we have the oversight over the building official. It's the building official that opens these avenues up that give us authority to oversight. Would you agree with me that that's correct?
I think the arguments are multiple. I think that the legality and the determination of the vehicle that we're using here and the arguments for whether the health and safety code applies for this commercial property rests with the courts and the judicial system. I do believe that the board does have the right and to determine factual determinations. Factual determination of human habitation occurring at the property, or the multitude of other 57 violations that occur at the property, if the notice and order was issued properly, and that I do agree with you.
Mr. Rosenblatt, do you need to proceed, or can I allow Mr. Lowe to go back and finish?
I would just like to make one point on that. Title IX, Chapter 1, in the section pertaining to the appeal by the board, and this is 9-1-215D. The authority of the Building Appeals Board to render a written decision shall be limited to the scope of authority of the building official in the first instance. So what Mr. Stewart has established today is that the state housing law is in force in Ojai. He's charged with applying that law. He did with regard to the notice and order. So he's invoked that code, and that squarely, I would submit to you, or at least for the board to decide, whether that comes under the scope of the authority of the building official in the first instance, in terms of the board's ability to decide if the state housing law applies to this building at all.
Thank you. Mr. Lowe, if you'd like to go back up to the lectern, we'd be more than happy to allow you which time you need. What I'm going to do is at 4 o'clock, it's 10 after 3, at 4 o'clock, I'm going to allow for a short break for the participants to use facilities. Again, 2 hours is stretching it. Maybe at 3:30. So you will be given as much time as you feel necessary to complete everything you have to say, though.
I hopefully will be done by 3:30. Earlier, I'd promised 5 statements earlier and kind of went off on a little bit of a tangent, but the fifth point that I wanted to make was that any subsequent repairs or any subsequent conditions of the property is of no consequence for this board. I think when the appeal was made by the property owner, it was regarding the notice and order at that time. It was based on the determination of Mr. Stewart and as a building official at that time. So any attempt to divert the board's attention away from that and the true and accurate conditions that exist on this property is of no consequence for the issuance of the NNO. That was the basis of the appeal. If you look at the basis of the appeal, he's talking about the appeal at that time. So any subsequent asbestos clearance, any cleaning of the property, any potential sale of the property should be discounted by this board. Also, any photographs that were produced that were taken a week ago of the property is of no consequence, because the photos speak for themselves and which have been produced at the time of the inspection and which is the subject of this notice and order. You know, I think in sum, you know, we have to get back to the main issues here. There was a lot of talk about notice and orders and issuances and everything here. So what do we have here? What has been produced by the city and the photographs of the city? The building official has cited this notice and order with 58 violations. Let's say you agree with 50 of them, or you say, okay, just clear cut 50 of them, there's 8 of them that apply. If you apply any of them, the appeals has to stand. The appeal has to be denied. And because if you find one, you have to agree that this was a proper vehicle for this. You know, the property owner has also blamed everybody for the condition of the property. Property owners owned this since 2000. It's been vacant since that time. I don't think there's any dispute on that. But look at all the blame that's been placed on everybody else. Problems were caused by Oprah Winfrey. Oprah Winfrey came in and they caused some of these problems. Holes were placed in the walls because they were exploratory holes. There were new owners, potential owners throughout the years who tried to buy this property, but it's just nothing ever worked out for them. You know what? The city didn't tell us that we had problems with the property for all these years until 2014. Or you know what? The city didn't tell us how to fix these problems. The city denied our plans. You know what? People were breaking in. That's who were causing the problems. The city was lying to us about the conditions of the property. The city's photographs are lying about the property. The building officials attempting to deceive us about the conditions of the property. This appeals process was not done right. What are we talking about here? We're talking about a building that is substandard. End of point, okay? It was substandard at the time it was issued. It's an analogy that we give to somebody who says, you know what, I got a ticket for speeding. But after that, I was driving the speed limit the whole time. It doesn't matter. You were speeding at that point in time, just like this building was substandard at that point in time. You know, the property owners hired multitude of professionals to help them out. So they're not an unknowing, unsuspecting purchaser who's not doing this. They've owned this property since 2000. They've hired an alleged engineer. They've hired an attorney. They've hired a property manager. To be frank, all of them failed there because the property is still problematic. It's a nuisance. Even in 2014, when the vacant building ordinance was ordered, they asked them to fix 3 things on the property. 2 of them still exist today. Whose fault is that? Is that the city's fault for fixing that? Do you need to get permits for any of that?
Which 2?
The 2014 were the palm fronds that are still on there, the landscaping issue that's still dead, and the chain link fence that still sits on the property. Okay? What we have here is we have the health and safety code doesn't require a proof of how long someone's habitated on the property. It just proves that human habitation existed there. Mr. Stewart, by his own testimony, saw bedding material, he saw toilets being used. It doesn't matter if someone broke in. The health and safety code doesn't say only if someone breaks in the property. It doesn't say you have to do it legally or illegally. It's a standard. It's like my analogy when I started. A public storage unit. Obviously, a public storage unit, the public storage isn't renting to somebody to have someone live there, but people have formed and made that a habitation. It's commercial property. Shipping containers that are empty, people have lived there. Sheds that are built illegally have been used as human habitation. The health and safety code doesn't say if the property owner allowed it, if the landlord allowed it. It just says human habitation. It was Mr. Stewart's professional belief, notwithstanding what Mr. Rosenblatt has tried to ask him, notwithstanding Mr. Hopstone's questions, notwithstanding anybody else's belief, he was the building official who was charged with his determination of this. He made a determination based on the evidence he saw, a door that was ajar, graffiti in the unit, and bedding material there, that humans had, and toilets being filled, that humans had habitated there. He didn't see them, doesn't mean it didn't occur. Fire or a tree falls down in the woods and no one hears it. Does that mean that it didn't happen? No, of course it doesn't. He saw evidence of it. It might not be direct evidence where he saw someone living there. It's called circumstantial evidence. Criminal courts allow it all the time, and obviously this appeals board should consider it at the same time. That the building official saw it with his own 2 eyes, and that's his testimony. That's the only testimony that said. And Mr. LaBar confirmed that when he saw beer bottles, he saw graffiti that was in there. He saw the door was ajar. This is a building that, by its own testimony of its property owner and its building manager, that there's no working smoke detectors in there. There's no working carbon monoxide detectors in there. There's no proof or indication that the fire suppression systems are even armed or mechanized or in a workable condition. There's photographs that are provided to you that show a roof that's filled with dead leaves on there, with electrical lines that are unsecured that are sitting there. If the electricity is on, as Mr. LaBar says, and that was flicked on, it's a tinderbox. The inside has photographs of electricity that's running down. There's electricity by water that's sitting there. That's photographs that you can flip through the pages and see. This building is clearly dangerous. You all know the location of it. You know that there are homes right adjacent to it. By their own experts stating, the part of the building may fall off and fall into someone's backyard. This is clearly a dangerous and needs to be abated, and whose responsibility is to abate nuisances? It isn't the city's responsibility, it isn't your responsibility, it's the property owner's responsibility. And regardless of all the excuses, that's where the true issues lay, okay? And she's the only one who can abate the problems. So I respectfully request that the appeals board deny the appellant's appeal and not uphold the notice and order. And I'm obviously open to any further questions that the board may have. Thank you.
I have a few questions. If,
Would you like to stand up here?
if you'd like to, whatever makes you most comfortable. I've looked through a number of these things and I'm distressed for a number of reasons.
Are you going to review the photos?
No,
Okay,
I don't have to do that. It's not necessary. In the past, what has happened is we've had repairs. I see permits were issued by the city. The fee were paid. I see where the inspections have been signed off. But I don't see where the rest of the inspections were done. So if we had a little patch here, we kind of went there. If we had a little thing here, we have a little thing there. It kind of seems that if we're going to have a problem or a problem building or a problem site, that when somebody gets a permit, we would have taken a few opportunities in the past. I see 3 permits in here. I'm distressed. It appears that some of this stuff could have been avoided. I have another item that confuses me, and so I'm one of those insurance guys. I don't know anything about the law. I see that a letter was mailed to the appellant dated August 28th, and they had to respond by September 2nd. October 28th is a Friday.
Can I see the, I'm going to.
This is your letter.
I just need to see the exhibit that we're referring to.
Sure.
What number is that?
I show Exhibit 5. No, Exhibit 4. Yeah, it is in the appellant's brief. I'm sorry, Mr.
Okay. Yes,
But
I see the letter.
It is your letter.
Yes.
Is that customary? There's the way I count time is you mail something on Friday, possibly it gets into the system on Saturday, nothing happens on Sunday. It's certainly not going to get there on Monday. And we have Labor Day weekend, and there's a demand for a call. And I'm just, as I look through this, I thought different tools were more appropriate. And with that, I'm done making any more comments. I've taken a look. I've seen, we've inspected it a few times. I do have a question for Mr. Hopstone.
Can I respond to
Oh,
that?
absolutely, sure, absolutely.
The letter may have been mailed on August 28th with requesting consent by Wednesday, September 2nd. But the city, by way of my law firm, did not set the application for the inspection warrant until October 21st. So it was over a month after.
No, and I'm okay with that. I'm looking at the letter and what it says. And you know, when it says you're going to consent, you're going to comply, and here's the time. Well, it's not 5 days because we got 2 weekend days, we got a holiday, and we got the postal department that does a very good job, but they're not Quicksilver. So I'm just, that just confused me. Even we don't do it that quickly. So, and that's okay. There's no other relevance to this. I just want to make sure that it wasn't correct. As I looked at a number of items in here, I became very confused with 2013 and 2015. It just didn't seem to make sense that we would do, and I'll find a reference, because I've got a lot of references here. The dating seemed to be a little different than I was accustomed to. And if you have nothing else to rebut with me on that, I'm not going to ask more questions here, but I am going to ask a question to Mr. Hopstone.
Okay, I was
Is that okay?
I just had a question about the dating.
Certainly.
I'm confused by which reference you're making.
You know, I have some references. I'd really rather not get into it. We can get into it to where I think there's maybe some typos in here and the difference between 2013 and 2015. Because if we come up with an item that says, you know what, we're receiving complaints, or we're doing this, we're doing that, and then it's not followed up for 2 years, it just didn't make sense to me in the narrative. So I'm gonna just go by that, because that is gonna be this huge time frame, and we've done inspections in the meantime. I think the other thing I looked at is that we've got problems with roof, but we went ahead and gave permits for the roof, and I would think if we gave permits for the roof and subsequent permits, that a roof should have lasted. I can't believe a roof can't last 15 or 20 years, and that kind of got in here. So we have other people that have things that are a lot more pertinent than I have. And I just have one question for the appellant's counsel. Do you have anything else to add?
Not right now.
Okay. And everybody will get to have last dibs on the answers.
Yes, Chairman.
I am looking at something here, and
Could you tell me which exhibit you're
yeah,
looking at?
I'm looking at. I can look at your exhibit and find the same information twice.
Either one. I have them both.
A notice and order was given, and the notice and order said, hey, we've got some palm fronds, we have some dead this, we've got a couple of that, we got a few of these, and we have the chain link fence. I'm trying to figure out what was inappropriate about not the state abatement order, but about our own vacant building ordinance 915. Was there an error in that when that order was initially issued on the chain link fence?
I want to make sure I understand your question correctly.
Then give me a moment and I'll find the exact letter.
No, you mean the 2000. The 2000.
Okay, Exhibit 3, City of Ojai,
Yes.
dated October 8th, 2014.
Was it error for the city to issue the 2014 abatement plan?
Was
That's the question.
there an error in this? What I'm wondering is why this particular request wasn't complied with.
That is a very valid question. As I understand it, there's an allegation of 2 violations. One, there's still some palm fronds out on the property, and 2, the chain link fence is still there. As for the palm fronds, and without getting into further live testimony, I'll make what's called an offer of proof, which is a summary of what I think I remember was testified to last time and what could be added to today if you want. As for the palm fronds, it's simply inaccurate. It's possible that he saw a palm frond today. You know, leaves fall down sometimes, but there has been regular and routine maintenance that my client is paid for on a monthly basis. The landscaping is maintained. The landscaping is mature.
I'll waive all that. We've had enough wind. We got trees. We got
So-
thousands of palm fronds, trees. We've got things
Okay,
everywhere.
so that's the palm
I
fronds.
want to get past that to the
The
fence.
fence. You're right, the fence has not been complied with. And in answer to your question, no, I don't think that there was an error on the part of the city for including this in an abatement plan. I believe that Mr. Labar's testimony was not a defiant refusal to address this issue, but he went in person, he met with the building department, and explained that the fence was needed to secure the property from the alleged vandals and the alleged transients. And nothing further came of that decision from the city, and the fence is not included in the current order. Having said all of that, the fence has been front and center of these proceedings, and as I'm going to address when I have an opportunity to present a closing argument, you know, I'm going to talk about remedies and the results the consequences that are going to follow of the various results of this hearing. Make no mistake, we don't think that granting this appeal means we get a pass and this property can exist in its current state into all of perpetuity. I know because of a procedural error, the fence gets to stay. I mean, if there are violations of the rules governing a vacant building, then we're going to have to correct those violations. I've already affirmed, contrary to what Silver said last time, I expressly agreed to meet and to discuss resolution. We're going to have to meet. We're going to have to fix it. And if we don't, then there are processes in the law by which the city can force us to do so.
Okay, I'm gonna restate that.
Okay.
So the fence was properly noticed.
Yes.
Okay, thank you. With that, we're going to go ahead and take a break now for 10 minutes, 12 minutes. At 20 minutes to 4, I'd like us to reconvene, get back in here, and then I'm going to be as silent as I can. Mr. Rosenblatt and the board will then have the opportunity to ask whatever they need, and then Mrs. Bizzano will certainly have a chance to have your people go ahead and retort. Thank you. Go ahead.
This is the light stand
Alright.
sign, okay?
Yeah, doesn't matter.
So that addresses that. They've been,
Okay.
okay? That's that number 4.
Thank you.
Oh, and
I'm trying.
There's a difference between tried and dead. My intent is not to be the building official. When you open up a door.
Mr. Ehrlich. Was that the graffiti you were talking about on the sign?
No, this has been whited out. This has been whited out.
Right, but
Okay.
this is the graffiti there that you were
No,
talking
actually, I think it's in, let's see here.
about. Yeah, it was
I think
on.
I
It
recall
was on
that.
the other.
It was on the lower part of the sign.
Right.
I didn't recall
But
seeing.
but you can see that it's been whited out. And that sign's not there anymore.
Right, it's still, yeah, lying in the parking lot.
No, it's not.
Well, it was as of, last Monday.
Yeah, it was, but it's not there anymore.
Okay.
Okay, no, this is what I was referring to.
Yeah, I know.
Okay.
I know that was.
We're going to reconvene. Now, Mr. Lowe, I wanted to make sure that everything you needed to say, you've had an opportunity at this time?
That's correct.
Okay. Mr. Hopstone, would
Yes,
you
sir.
like to take over? You can certainly take over there. That's
Okay.
appropriate. That makes it easy.
Well, you can sit down, I mean.
You can do it.
I think I prefer to stand.
I think that would be great.
Good afternoon, Chairman Daddy, and other members of the board. My name is Joshua Hopstone, and I'm an attorney with Ferguson Case-Or Patterson, a law firm in Ventura representing the owner of the property that is the subject of this action. I think we can all agree that everyone who is in the room who has sat through the proceedings on Wednesday and today have learned a great deal about this property and the events and circumstances that led to us all being gathered here today. I certainly am no exception. I've learned a great amount listening to testimony of the witnesses and the attorneys and the questioning from the board that gave me a different perspective on a few things that I did not gather just from what had been written down on paper and what had been provided to me. one of the things that I left Wednesday with a little bit different perspective about was that the city and the building department and building official Stephen Stewart in particular, I feel, is entitled to an acknowledgement that the property owner and her local manager may not have been as responsive as they should have been to his inquiries back in 2013 and 2014. The picture that I had was really rosy, and it sounded like he had made concerted efforts to try and get a response that was not forthcoming, at least not to the extent that he would have liked to see. I don't think that it was malicious or deliberate defiance or things of this nature. I think that the scope of what Mr. Labar has authority to do on a day-to-day basis is limited to that, and as these inquiries and investigations and inspections and so forth are becoming more substantive, he has to coordinate with the owner and, in any event, it doesn't really matter now because we're all here now, but Mr. Stewart is an official of the city, and when he makes an inquiry or he needs some information, then it's not just respect. I mean, that needs to be forthcoming. So I wanted to say that, but at the same time, I feel there is a disconnect between those limited interactions in 2013 and 2014 and the immediate events leading to where we are today. Because in 2015, there was one and only one correspondence in connection with this property. It's a letter dated August 28, 2015, and it was mailed to Gail Bazzano in Louisiana. It's undisputed, no second notice, no second letter, no telephone call. In fact, it is disputed that she ever received this letter. Benefit of the doubt, we will assume it was mailed, but it was never received. It's also undisputed that no copy of this letter or any notice, telephone, written, or otherwise, was provided to Mr. Labar, who is registered with the city as the property manager and who historically for the last 15 years is on a first-name basis with the building folks. They know him. They know he's the property manager. No letter, no phone call, no copy of this same August 28 letter that was sent to Ms. Bazzano was sent to Doug. Instead, they elected to go to court and seek an inspection warrant. The result of that warrant was a notice and order to repair or abate dated December 11th. And I'm going to try and track the 5 issues that the city's special counsel raised in the context of that order. His first point is that it is beyond the scope of the authority of this board to consider legal issues or consider what the law is or consider the application of the law to a particular set of facts. And I don't know what to say to this other than it's simply inaccurate. I mean, he cites there is one case cited in that brief in support of that, and it says an administrative agency has no authority to consider matters of constitutional magnitude. So we're not asking the board to say, we declare that the California Health and Safety Code is unconstitutional. We're not even asking to say that it was unconstitutional as applied in this case. We're asking the board to recognize the obvious, which is that the State Housing Act does not apply to a vacant, unoccupied commercial building. That's not a question of law. That's not a question of fact. That's not even a question. This is expressly set forth in the terms of the rule itself. Now, this board was enacted in 2013 and was given the final authority of the city with respect to this order. And one of the sections which Mr. Rosenblatt read verbatim states that, and states that after a written decision, the order is the final and binding decision of the city, and any further redress is to a superior court by petition for writ of mandate. Well, the rules of of administrative mandate also directly, expressly contemplate a review of whether the administrative agency properly applied the law. The reason they're arguing so forcefully against any consideration of legal issues is because it's obvious. The alternative argument that, well, maybe the health and safety code doesn't apply to a commercial building, but this building is a building that can be used as a dwelling for human habitation. That's what's set forth in their brief, and that's was repeated here today ad nauseum. We went through some of the evidence which they say proves indisputably and beyond any doubt that this building is being used as a dwelling. People are living there or have lived there in the past. But I ask you to consider what the evidence is of such a conclusion. There's evidence that Mr. Stewart saw some poop in the toilet. That's gross. He saw some beer cans, and he saw some bedding on the floor. Notably absent from any of these 50-plus pictures is any picture of any bedding. And if I missed it, please correct me, counsel. But dozens and dozens of photos of what seems like every inch of this building. There's no bedding. There's no clothing. There's no beer cans. There's some of a toilet, and it's kind of hard to make out. Maybe there's poop in the toilet. It's hard to tell. But you would think that if this was such the pinnacle of their order, the pinnacle of the case against my client, they'd go ahead and snap a photo of that bedding too. The testimony of Stewart was disputed by the testimony of LaBar, who said there's no evidence whatsoever of anyone living in this property for even a minute. There's no evidence of bedding, there's no evidence of residence or any of the other things that would lead one to indicate that a property is being used as a dwelling. But even if it had been, even assuming for argument's sake there was bedding and someone was, some criminal had broken in and was using this property as shelter at some point in the past 20 years, that's not sufficient to establish a building as a residence subject to the health and safety code. And if you push that idea that it is to its logical extreme, it could reach virtually anything, not even the things Mr. Rosenblit mentioned, such as a church or this city hall, but a bus stop. I mean, if someone's using an oil rig as shelter from the rain, is that subject to the health and safety code because it's being used as a residence? The law provides very clear guidelines and very clear criteria about what laws apply to what structures. And in this case, like I said, it's not even a question. I mean, the law pursuant to which this order was issued does not apply. It does not. That's not a question of constitutional magnitude. It just doesn't. It took me about one day to figure this out after I was retained on January 4th, and the next day, January 6th, I attempted to engage the city in the appeal process that is set forth in the law, in the Ojai Municipal Code. We filed an appeal pursuant to the vacant building ordinance, the ordinance that is expressly alleged to have been violated in this order, and said essentially what I'm saying to you now, although I've had a little more time to flesh these ideas out. The health and safety code doesn't apply. That appeal was rejected. My clerk was turned away. And that night I sent another copy by email to Mr. Matt Silver requesting an explanation for why this is unappealable, why we cannot participate in the rules that Ojai has set forth. And he responded same day and says effectively, well, we'll look into that and we'll get back to you. And you don't need to take my word for it. This exchange is Exhibit 14 in the binder. I mean, this is perhaps not verbatim, but it's all before you. Okay, that was January 6th. All of January, all of February, all of March, all of April, and we're coming up on the end of April. It's been almost 4 months. And then last Monday, April 18th, 2 days before the hearing, is the one and only comment from the city of Ojai that we ever received on application of the health and safety code to this property. Okay, now that puts me in a position where I get this, I'm in a deposition in Riverside, and this comes in over my email. Puts me in a position where I have worked 36 hours around the clock to try and respond to this, what we say is an erroneous legal position, and managed to get it done and submit it Tuesday. And then on Wednesday, I'm accused of extreme prejudice to the city of filing so late. You know, those were Mr. Silver's words, the extreme prejudice by Mr. Hopstone of ambushing the city with what our position is on these issues. It's the city who knew these issues for over 3 months, almost 4 months, because I filed an appeal to that effect back in January, and it had no response until 2 days before. So suffice it to say, we did the best we could in response to what appears to be a process that the city has just been making it up as it goes along. During that time, well, let me back up. You know, this notion that all of this is noise, everything that we've said in this appeal, what I'm saying to you now is a big distraction from the real issues in this case. And the real issues in this case are the building is run down, and the building does not today conform to the laws by which a brand new structure that is erected today would be required to adhere to. Well, guess what? It's not required to. There are laws which apply to vacant, unoccupied buildings. Those laws are set forth in the Ojai Municipal Code, codes which the city has alleged my client violated, but codes which it itself expressly, and to this day, adamantly refuses to acknowledge that it was required to adhere to. It alleges that my client violated the vacant building ordinance, a law which was just passed a couple weeks before it took action against. Council shaking his head. There are express allegations of violation of the Ojai vacant building ordinance in the notice and order to repair or abate. And this is an exhibit before the board. And yet, there is no dispute that no abatement plan was prepared for this property. There was also a comment that...
I'm sorry to interrupt you, Mr. Hopstone, but just for a point of order, point of clarification, are you referring to this to the lack of in 2015 a abatement plan generation and issuance by the city, correct?
Yes.
Would you please comment or include somehow, or give me a reason why you're not including the abatement plan that you referenced earlier from 2014?
Sure, yeah, and I'm going to read from the Ojai Municipal Code because I think that'll...
And also, point of order, since you made reference to when it was that particular section of the Ojai Municipal Code, it was first, according to my information here, adopted in 2010, December 9, 2010.
So it was updated, not enacted?
Yes, yeah, the reference to it was only adopted on November 14, 2015 is erroneous by 5 years
Okay.
and 1 month.
I stand corrected.
Well,
I meant updated.
As being a practitioner of details, details. So please continue.
Updated. I'm going to read from section 9-15.12, abatement plan. The director shall prepare a written abatement plan for all vacant buildings within the city. Prepare a written abatement plan for all vacant buildings within the city. The abatement plan shall set forth in detail those items and actions required by the city in order to bring the vacant building into compliance with the provisions of this chapter. Subsection C says, well, subsection B requires that the abatement plan be served. C says that in addition to service of the abatement plan, each owner shall be notified that he, she, or it has 90 days in which to obtain any necessary permits and complete any and all remediation required by the plan. And then provides that the director, upon good cause, can give an additional 90 days.
Would you pull the microphone a little bit closer?
I'm gonna
Because
stand closer.
the people at home aren't going to be able to hear any of this proceeding.
Subsection D says that an owner may appeal any or all requirements for abatement set forth within the director's abatement plan within 21 days. So the 2014 abatement plan, which identified 3 alleged deficiencies with this property, the palm fronds, the fence, which admittedly is still an issue, and the
Overgrown and/or
newspapers.
dead
the-
vegetation.
The newspapers. There were some newspapers on the
Oh,
property
yeah,
too.
accumulation of
Um,
newspapers.
Okay, that does not comply with the requirements of this rule, which obligates the city to set forth in detail those items that the city requires to bring the property into compliance. Now, if the city wanted to move back in 2014, maybe we would be in a different situation. But it moved in 2015, and it didn't prepare an abatement plan for the violations set forth in the order.
A query then, since under the city letterhead, this letter, this referenced a transmittal of October 18, 2014, which is over the signature of both the building official, Mr. Stewart, and the Community Development Director, Kathleen Wald, is titled Vacant Property Maintenance, Security, and Registration Abatement Plan. So does that, your assertion that it does not constitute an abatement plan seems to be
No,
in conflict with what's its title. So
To me-
you're saying it is an abatement plan, but it is not, doesn't comply with the requirements of the municipal code?
No, that's not what I'm saying. To be clear, let me try and clarify, because I'm not being apparently. The 2014 abatement plan, as far as I can tell, was properly issued and identifies conditions that were required to be abated. In 20
And at least one of them subject to interpretation about palm fronds and circulars and newspapers. At least one of them, the fence, the 6-foot chain link fence with barbed wire, is still at issue as far as noncompliance with this, whether it was a correctly, duly issued abatement plan or not. It is still an outstanding issue.
The fence is still out, the fence is still there, yeah. And I don't think we've ever alleged that the 2014 abatement plan was violative of the Ojai Municipal Code or the vacant building ordinance. We're here to talk about this appeal is an appeal from the notice in order to repair or abate in 2015, which alleges violations of the VBO, but which did not contain any of the requirements of the VBO.
I got that. So what you're saying then, in essence, is we're not, as part of the evidence that was included in your brief and included in the city's brief, Mr. Silver's brief, we're not to consider that?
We included it as an exhibit. The testimony is undisputed that the fence is still there. The testimony from our side is that we specifically addressed it with the city, and
Specifically addressed it how?
by going to the building department to discuss specifically the issue.
Right, but that seems like, you made reference in your brief to the November 25, 2014 letter from Mr. Stewart that was also addressed to Ms. Bizzano, that was a follow-up to the October 8. Okay, and my understanding, since you made reference to it in your brief, is that it wasn't until January of 2015 that Mr. Labar came into the city to discuss. There was an invitation in this, inherent in this November 25 document.
That sounds accurate.
Okay, having said that, okay, there was a conversation, but, and my understanding of allegations and representations that I've heard is, during the course of this proceedings, that Mr. Labar communicated to Mr. Stewart, or whomever he spoke with, that the owner had no intention of either addressing the palm fronds or addressing the fence at that time.
Not accurate with respect to palm fronds. I understand there's I guess, a dispute of fact about the palm fronds, but yes, you're right. Mr. Labar communicated the security concerns about why the fence.
Okay,
Okay.
and as from that perspective, that was considered put to bed as far as the issue of it being in violation of an abatement plan.
Nothing further was heard from the city with respect to the fence.
Okay, so we can consider that at this point to have been the final determination, final word by the owner's representative, Mr. Labar, that the owner was not going to cooperate with the abatement plan.
I wouldn't characterize it in those terms, and
How else
Gail, I
could
don't
you,
want,
please characterize it in some other terms then?
just as I previously expressed, which is that he expressed his security concerns, and
And it was expressed verbally.
do you want to say what you said, Doug?
And so there was a verbal response to, in a conversation with the city official in response to a written, two written documents.
I wasn't there, so if it's all right, can I ask Doug
Absolutely.
what was said? Okay,
Absolutely.
thank you.
Yeah, my name is Doug Labar. What I recall happened was I got a copy of the November 25th, 2014 violation of vacant property maintenance, security registration, all that. And I came to the city to inquire about what was really meant by that in light of the history of having the building violated by whoever violated it, the damage that was done to windows and such that we had to board it up. It was decided to put in the fencing, and getting this notice, at the time, I would have had to have cleared.
Doug, let me ask you this. How did the conversation end? When you expressed these concerns about security and so forth, what did Mr. Stewart say? Where did the conversation end?
I said that I would have to check with Ms. Pisano about taking the fence down, but that I thought that it would be ludicrous to try to take it down because of the fact that people already park their cars in the front along the street and try to sell them. The place would
Doug,
turn into
Doug. And what did Mr.
used car
Stewart
lot.
say? You said you would check with the owner, and Mr. Stewart said either, okay, get back to me, or he said, no, that's not acceptable, or where, do you remember what was?
I don't remember what
Okay,
Mr.
that's
Stewart
fine.
said.
That's okay. Gail, I don't want to put you on the spot. Do you want to speak for 2 minutes about the fence? Your thoughts on the fence, or no? You know, we've spent, seems like hours on an issue that is not in the order that we're appealing from, but please.
It was never my intention to defy the city of Ojai, and that fence is rented. I have paid, I don't know how much for that rented fence, and I could easily call the fence company and say, take the fence away. And the problem I had with that was that then what kind of liability, could I get liability on this property? What would I be able to do for insurance purposes, for any purposes? And I was never given any guidance. No one ever told me, well, make the fence X lower. I pointed out that the Forestry Service had a razor wire fence on the one side of the property, like in a prison. And I went over one day and I asked the Forestry Service people, I said, why do you have this razor wire fence there? And they said, well, because we need to protect our property. That was the end of it. Then I went over and I looked at the golf course, and it had what looked like a 10-foot high chain link fence, and that's just right across the street from my property. So I just guess I never got the right feedback. Please, forgive me for not following it up at the time, but then it was dropped and I didn't follow it up.
Gail, let me ask you this. If 30 days from now, if we meet with the city and come to resolution, come to some sort of manner by which we're going to bring the property into compliance with the laws that apply to a vacant building, and the city insists that the chain link fence be brought down, are you willing to take it down?
Absolutely.
And you think it would be possible to have it taken down within 30 days?
Absolutely.
Okay. Do you have any objection, or are you insisting that the property stay up for any reason?
No,
I'm sorry,
I'm
the
not
fence, the
insisting that.
fence. Sure.
Yeah, I have a question. Why would you want to take down the fence if it's believed that the building's being occupied by?
We've just spent 2 days being accused of violation of an order because the fence is still up. And we're going to need some kind of replacement, some kind of security replacement, and we're going to have to work with the city to come to what that replacement is. Your question is what sounds like what Labar asked Mr. Stewart. And you're absolutely right. I mean, over the course of the last 16 years, there were concerns of vandalism, there were concerns of unauthorized entry, and a fence was erected, a rented fence. And we just spent 2 days defending against, the defiant, intentional violation of the 2014 abatement plan, which has three alleged defects, this fence. So that's why we want the fence to stay up for security purposes.
To your knowledge, was there ever a police report or the fire department located right across the street? Were there any reports from them, the police department, any records that there was actually people living in the building, or were they concerned?
We never, ever had any record. We never even had any evidence of anyone ever living in the building. We had evidence was of vandals who broke the windows, and we fixed them, and then vandals broke them again, and finally we put boarded them up. But that was behind the building, behind a hedge. No one could have seen that unless they got in and went to look behind the hedge. No one ever would think, to my opinion, of living in that building. It just, there would be no reason. This isn't a town where there are vagrants who have to find some place to live. It's absurd. It's totally absurd.
Years ago, I owned some property in Ojai that was commercial, and we had from time to time people wanting to live there. And I was constantly notified by the police department to do something with it.
That never happened to me. It just never happened. And Mr. Labar lives blocks from the building, and he knows as well as I do it didn't happen.
And perhaps this was asked last week, but let me ask again to confirm, Doug. Did you ever find bedding, a mattress, or anything of the sort in the building?
In the entire time that I have been managing the property, I have never seen any bedding or clothing or like fires or anything inside of the building. The day of the inspection, I saw 2 beer cans, and that was it.
Okay, you've looked through the photos the city produced, yes?
I've looked through through the entire brief and the pictures.
To the best of your knowledge, is there any bedding or any evidence of
Not
residents in
pictorially,
any of
there
the
isn't.
pictures? And were you present on the day of the inspection in November of 15?
Yes, I was.
And did you see the bedding that Mr. Stewart's referring to that day?
No,
He didn't point it out to you?
no. And I didn't see any on the inspection on the 2013 with Larry Beam either.
Okay. Now, bedding or no bedding, how about just sleeping on the floor? Have you ever seen another person in this building?
Never,
16 years.
never.
Okay. Have you ever seen any evidence beyond bedding? Any evidence that would lead you to believe that any person was spending any amount of time other than perhaps vandalism?
And the vandals when we stopped the vandals, when we put up the fence, because there was evidence of forced entry. The day of the 2015 inspection, there was no evidence of forced entry, even though the door with a double deadbolt was ajar, and we were able to trace that to an Edison meter reader that had to come in.
Thank you.
Excuse me, how long had the fence been up?
Sorry?
How long had the fence been up?
I can't tell you specifically, 5 years or more.
About 5 years, she said.
That fence company that you're talking about, there's been a fence around it all, as long as I've owned it.
Since 2000, the fence was there?
I can't, maybe not that same fence, but a fence.
On the subject of, are there any other questions about the fence?
Yes, actually. It's not clear to me at this point, well, perhaps I can synopsize. Mr. Hopstone, on behalf of your client, you are appealing from the city's assertion of violations of multiple state code sections. And there's a lot of legal, shall we say, controversy or difference of opinion relative to the applicability of state codes, Ojai codes, et cetera. But the upshot of what we've been hearing now for almost 5 hours is that the city was in error in not only applying those code sections, but in procedurally relative to the abatement notice. And yet we keep stepping over and avoiding, apparently, what appears to be, and whether it's two issues or one issue, the fence is an outstanding item on an outstanding abatement order that was included in your brief. And so, an abatement plan, excuse me, correction. What is you made reference to perhaps sometime in the next ensuing time period, the city and Ms. Bazzano may be able to come to some conclusion about that. But I believe you just stipulated that it is still an outstanding violation pursuant to that abatement notice from 2014, as well as the abatement plan of 2014. And subsequent conversation about it wasn't even memorialized. So I think it's, at this point, it seems to be clear to me, I don't know to anyone else, but it's still an outstanding issue that's not being addressed. And it is violative of the Ojai Municipal Code and has been duly indicated as such, and it noticed, and it advanced and responded to. So while we have all of this technical concern, which regardless of the outcome, I'm still wondering why we're stepping over this apparent outstanding violation.
Mr. Ulrich, Mr. Hobstone, too much stuff in here, so let's go back. You're not appealing the 2014, you're appealing the 2015 order.
Correct.
The 2014 order is still up to the city to do with what they want.
Yes.
In your understanding, or what you're telling me, and I will refer to my attorney, is that we're here today to only deliberate the 2015 order. Is that correct? Is that your understanding? Or do we have both orders in there?
Yes, almost exactly yes. You are correct that this is an appeal from a notice in order to repair or abate that was issued December 11th, 2015. We've appealed from that order, and we're challenging it on various procedural and substantive grounds. Now, Board Member Ulrich has expressed that we continue to kind of hide or skirt over or avoid the fact that the 2014 abatement plan was issued. I'm trying my hardest to express that we do not deny that happened. It's expressly set forth and summarized in our brief. The order itself is attached as an exhibit to our brief. And as I've stated, as we've talked about for 20 or 30 minutes now, there is an outstanding violation of the 2014 abatement plan. You've heard testimony that we're willing to correct it, and if the city is inclined to continue to enforce the 2014 abatement plan and the conditions identified in the 2014 abatement plan, well, there are procedures in the code by which the city of Ojai may go about doing so. But there are 58 other violations for which no abatement plan was ever prepared. That's undisputed. And those are the violations that have been charged against my client and are being appealed from today.
Mr. Hofstone, to build on what you just said, and just to, Chair Daddy made a comment that I think goes to the heart of this. The notice and order, as far as I can tell, does not allege a violation because a fence is there, or because it's dilapidated.
Correct.
Or because it may violate the zoning code.
Correct.
It's not an alleged violation in this notice and order.
No.
And that's what's before the board. The fact that the city issued an abatement order in 2014 doesn't have anything to do with what's alleged in the notice and order. And quite frankly, you make a statement in your appeal brief, which is not supported by authority, by the way. You state the invocation of a particular framework carries with it the obligation to ensure that the framework's procedures are adhered to, at least for the claims arising from that specific framework. You're arguing, as I understand it, that because the city invoked Chapter 915 in 2014, and because it alleges that there's improper landscaping in the notice and order, and there is a failure to properly maintain landscaping, specifically determination numbers 53 and 55, that somehow Chapter 915 is in play with regard to an abatement plan.
Well,
I just don't see the logic. The city issued an abatement plan. It could have pursued that. And by the way, I've heard nothing about a timely appeal, right? 915, I think point 12, speaks to an appeal of an abatement order within 21 days. There's been no evidence about that, and I don't see the relevance of it to the board, because the notice and order is just mentioning two conditions that happen to be within Chapter 915 with regard to landscaping. So what relevance is the abatement plan?
It's the absence of an abatement plan.
So why does it matter?
It matters because it is a framework that the city expressly invoked. And did you mean that no time?
Invoked it in 2014, correct?
Yes?
Now, let's say it switched tracks in 2015. It did something in 2014, specific to Chapter 915. Has an inspection November 3, December 11, and issues an order, okay, under the Health and Safety Code. And there's express authority in Chapter 915 that says violations of this chapter may be enforced in any combination of remedies allowed by this code or by law. That clearly, would it not establish discretion in Mr. Stewart to decide which remedy to bring to address a problem?
Certainly. Yes.
So he chose the state housing law to issue a notice and order. And he chose to capture within that notice and order two conditions of Chapter 915 that happen to pertain to landscaping. So there's no authority for your position, and I don't see it in Chapter 915 at all, that says once the city issued an abatement plan, it had to carry through every administrative procedure in that chapter. Am I reading something wrong? Am I missing something in that chapter?
It was not clear to me, and I guess I need to read the abatement order again, but I did not, it was not clear to me that the allegations of 915 in the abatement order were limited strictly to the landscaping, but I do have a copy here. In any event, it is not to say that, certainly it is not to say that the existence of the VBO precludes Mr. Stewart from enforcing the Health and Safety Code or any other applicable framework. The VBO says expressly it may be enforced in combination with other remedies. Title 5, Chapter 6 says expressly it may be enforced in combination with other remedies. Those are set forth verbatim in our brief, and it's not something we're hiding behind.
All right, so you're acknowledging that your claimed procedural defects have no merit?
No, I'm not. I'm expressing that once the building official made a decision to, and I'm talking about 2015, December of 2015, once he made a decision to invoke Ojai Municipal Code violations, the city at that point had an obligation to follow its own rules.
That's argument. What's your authority?
I have none beyond common sense, with all due respect. I mean,
Well, by invoking Chapter 915 in determinations numbers 53 and 55, right, the city has to prove that those conditions exist by a preponderance of the evidence. And your client's getting due process on the existence or non-existence of those alleged violations before the board in this hearing.
well, thank you for pointing this
So,
out.
no, you know that, but you seem to be asserting that somehow, by not continuing with an abatement plan under Chapter 915, that there's some procedural defect in the notice and order. And I'm concerned that the board may not understand the rationale for that.
The procedural defect is not contained within the notice and order. We're put in a position where we have to prove a negative. I mean, at this point, it's undisputed, but the Ojai Municipal Code requires the preparation of an abatement plan, and one was not prepared. This document was served on us instead, and now that I have the specific references, so 53 is the landscaping, and 55 is vacant property maintenance generally. Maintenance of the property is so out of conformity with the maintenance standards of adjacent properties as to cause substantial diminution of enjoyment use or property values of such adjacent properties. Properly maintain the vacant structure as required by local law, including but not limited to properly maintaining the landscape and vegetation, properly repairing and maintaining the structure, and properly securing the subject property. So, admittedly, overbroad. I mean, very general. It's difficult to say what specifically we're required to do in response to a requirement to maintain the structure and properly secure the subject property.
Where is it stated that a notice and order has to define with clarity and completeness each and every corrective action that has to be taken?
Nowhere. It doesn't. That's the abatement plan. The abatement
Well,
plan.
that may be a plan under Chapter 915.
And that's what this is alleging my client. That is what this number 55 charges my client with violating.
Well,
So our
it charges a condition that may or may not exist. The board needs to decide if the city's proven its case. As to that condition, nothing more.
So it
The
seems.
board doesn't reach what required compliance is.
Okay, so it seems to me like this is an abandonment of at least this number 55.
Well, let me ask you something. If it's, the building official alleges that it's an unsafe building, and it's a dangerous building, if those are violations of the city code, is it your rationale that the city has an obligation to prosecute your client criminally? Because in Title I, Chapter 2, it says it's unlawful for any person to violate any provision of the code. So if the city declares conditions to exist that violate the code, is there suddenly an obligation for the city to prosecute your client, to invoke the criminal remedy? Or is that in the area of discretion?
Discretion.
So how's it any different with Chapter 915? The city's alleging two conditions exist that are contrary to a provision in that chapter. And you're bringing compliance and how that must occur before the board as if that's within the scope of the notice and order. How's it relevant? The board's here merely to decide if a condition exists or not. That's it.
The difference.
I'm stating an opinion for the board. You're free to disagree. If you think the board has other duties that, go beyond what I just stated, please make your case, but.
No, I understand, and the point is well taken. My point was that the difference between the example you gave with with discretion, whether or not to institute criminal proceedings, is just that discretion. And in this case, it's moved beyond discretion into action.
How so? In the notice and
Well,
order? In the notice and order. How's it done that? In the notice and order, it alleges the existence of nuisance conditions in another chapter. By your rationale, and I read that quote from your brief, must the city initiate an administrative action to declare a nuisance with a right of appeal going to the city council? Must it invoke the procedures in that chapter?
No.
Now, that chapter would afford your client due process. If the city chose to proceed under 915 and there was a timely appeal, the planning commission you'd receive due process before the planning commission. But that's not what the city did. It issued a notice and order under the state housing law. It captured conditions that violate other provisions of its code, and it included that in the notice and order. And you have a due process hearing about whether the conditions exist or not, and no more.
Okay, well, I think this is a point where, your point is well taken, Mr. Rosenblatt.
Okay.
And my last point, which is something I'm going to segue into, is that the actions of the city went beyond just a notice in this case. They actually took further action by recording documents on my client's title pursuant to the government code.
Now,
And
I'm sorry, go ahead.
And that's what I wanted to address, because there was a comment from opposing counsel that there was no special tax assessment or anything.
Well, let me save some time. That's not in the notice and order.
Correct.
Whether the city did that or not, whether it had the authority to do that or not, isn't that irrelevant for purposes of this hearing? The board, by the code, is mandated to consider relevant evidence. So the recordation of a document, which the notice and order is silent about, how is that relevant to what's before the board, which is framed by the notice and order and your appeal?
Well, the reason that we contend it was relevant is because, and by it I mean the recording of this very same notice and order on title, is that it was recorded to an alternative framework, an alternative section of the Ojai Code, the title governing nuisance abatement. And I'll speak just briefly about this document because I think the document speaks for itself. But to be clear, on January 6th, the same day that my appeal was received and rejected, a document was recorded in the Ventura County Office of the Recorder, and a copy is attached to our brief as Exhibit 15. This document says on its face that it is being issued pursuant to Government Code Section 27297 and 38773.5. 27297 deals with authorities of boards in general, and it does not provide any specific authority with respect to recording documents. The operative section under which this document was recorded is 38773. Now, what that law says is that legislative entities are permitted to enact rules for themselves for how to govern public nuisance abatement. And the city of Ojai did enact such a rule in the year 1968. It's now found in Title V, Chapter 6 of the Ojai Municipal Code. And under that rule, it says that the city of Ojai is permitted to enact a nuisance abatement action against a property owner, and if provides for notice and a hearing, basic due process considerations, and if none of those are properly responded to, the city may elect what's informally called self-help. The city can go in and it can abate the nuisance itself, and it can enforce the cost of doing so as a special assessment against title to the property. Mm-hmm. Now, this document, Exhibit 15, page 2 is printed on a Superior Court of California caption, and the text of the document says that an action has been initiated by the city pursuant to these sections I'm describing that may include administrative, criminal, and civil proceedings to abate. So this is beyond, recording this document goes beyond the building officer's discretion of whether to invoke a particular legal framework. It, in fact, did at least initiate that legal framework by recording this document. And as a factual matter, it should not be overlooked that the document was signed on December 29th, which is within even the 30 days that the building code requested for compliance. If you recall, the notice and order of December 11th said that, in layman's terms, the December 11th, 2015 notice and order to repair or abate said, owner, you are required to bring this property into compliance with all the laws governing dwelling used for human habitation. And you have to start work within 10 days and complete all work within 30 days. Well, 18 days later is when they recorded this document on title. And the fact that ancillary sale proceedings were going on, and the fact that this document was a lease pendants and a cloud of title in the course of those proceedings is not irrelevant. But the point with respect to this is that the difference between a simple notice and the building officer's discretion of whether or not to pursue a particular legal framework is different from this case, because they did go beyond just the notice. They recorded the notice pursuant to the California Government Code, and put the owner on notice of a pending action that's going to result in a special assessment against the tax roll.
All right, so was that instrument rescinded?
Yes,
Yeah.
yes.
Can we move on?
We certainly can.
I have a few questions, and maybe we can dispense with some of the 58 citations. I recall during the BAB discussions in 2015 that led up to the updating of the vacant building ordinance, that the city attorney, Mr. Summers, was careful to note that the purpose of the vacant building ordinance was to protect public health and safety and prevent blight and damage to local property values. As a result, he said, the state of the interior of an otherwise secured vacant building should not be citable under the vacant building ordinance. For example, he said, a vacant office building or residence could not be cited for lack of furniture inside if it was secured and not blighted on the exterior. As I look at this property, most of the citations are regarding conditions on the interior of the building, and it is not clear to me that those citations are appropriate. I personally, and I don't know how the rest of the board feels right now, I personally do not accept the argument that the bowling alley is a residence or a dwelling because people could live inside, even if the water and electricity are turned off. That line of reasoning would make my detached garage a residence and make that building subject to the state housing code, even though there's active electricity inside and no plumbing. Someone could sneak into my garage and sleep overnight there. And I think that's a specious argument at best. And I would contend then that citations of the exterior of a secured building, an otherwise secured building, are appropriate here, and citations regarding the conditions of an interior of a building not designed for human habitation are not relevant here. That doesn't leave you completely in the clear, Mr. Hopstone, because there are some citations in the notice and order that are yet to be resolved that have to do with the exterior of the building. Not the fence, that was earlier, but still the exterior of the building. But I think, in my opinion, we should dispense with most of the citations here. It appears to me that the relevant health and safety issue here is whether or not there could be a fire in this building that would endanger residents or other buildings in the area. And both sides have, both the city and the appellant have failed to produce any evidence that the fire suppression system was tested and shown to be in a condition that would prevent a fire in the building. So I find both sides at fault in that. You've already agreed that the 2014 thing was legal and appropriate. It's not really an issue here. I presume that because the 2014 letter didn't say anything about securing the building per se, other than taking down the fence, didn't say anything about registering the property, didn't say anything about registering a property manager who would monitor and status the property, that all those things were done properly at that time. Is that correct?
That's my understanding.
Okay, fine. All right. Was it at any time, this is for the city, was it any time that you're finding that the building was not secured so as to protect the public safety? If so, when was that? Was this the door ajar on November 2nd? Was there any other failure to secure the property other than the
not supposed to be there fence.
I just want a point of clarification. Are we talking about what time? Because, frame are we talking about? Because Mr. Labar has even testified that he's had indications of vagrants coming in there at a time before. I'm wondering what time frame are we talking about?
Yeah. Well, my question, I think, is straightforward. At what time did you find that the building was not secured, if you so found?
At the time of the inspection based on the notice and order that was given.
Okay, so that was the door ajar at the back of the building that you found on November 2nd?
Correct.
Okay. Is the property properly registered and the property manager properly registered with the city?
I can't speak to that right at the moment. We'd have to do some research. Keep in mind, Council, or Board Member Quillisi, you're making reference to the vacant building ordinance, and we're not prepared to speak to that today. We are totally prepared to speak in regards to the notice and order violations, which my understanding does not have a provision in there that we cannot require elements inside the building. That is just for the vacant building ordinance.
You can do anything, you can cite things inside a building if it's a residence or a dwelling unit or whatever, which is, I understand, your contention.
My contention is under the sections that we've quoted, under the notice and order, we can cite elements that are unsafe inside the building. You're absolutely correct, under the vacant building ordinance, that is not subject to a hearing or a violation noted.
But those citations are citable under 17920 or wherever if you assume this building is a residence of some sort.
That's correct.
Okay.
I've already asserted the fact that I believe it was used as a residence. It's up to the board to either uphold
Got it.
that
Yep.
determination or not.
Okay. At the April 20th meeting last week, Mr. Labar described a telephone conversation with the city building official regarding the timing of an inspection of the property. He later followed up that same day, I guess, November 2nd, with a letter to the city to the same effect, asserting disputes over the timing of an inspection and such of the building. Were those assertions correct? Did he describe the conversation with you correctly?
Absolutely not.
Would you like to tell me what the conversation consisted of from your point of view then?
Absolutely, I'd be happy to. A discussion was considered after we received a letter from the property owner that the only way that we would be allowed an inspection of the property is if we gained an inspection warrant. We had no other recourse from the city's perspective but to get a warrant.
I'm not
For that purpose
questioning
is
the
that.
existence of a warrant. I'm talking about the conversation about the timing of the inspection.
I wanted to give as much notice as I possibly could to the property manager in regards to allowing us access into the property. I asked my building inspector to contact Mr. Labarge and tell him that we were going in the following morning at 10 o'clock, and that if he could have, be there or have somebody available to let us in, we would appreciate that.
And if not,
Subsequent to that, he contacted me via phone, and I reiterated that request. I told them, and I may paraphrase a little bit, but this is my best recollection. I told them the warrant gives us authority to enter the building by cutting the lock and knocking down the door if we need to. My hope is that you will allow us in the building without having to do that. Furthermore, I had no intentions of cutting the lock and knocking down the door. I made provisions at the 10 o'clock inspection to have a locksmith being paid by the city on standby to open the lock and to open the door, so we did not have to do that. Fortunately, Mr. Labarge opted to allow us in, and I appreciate the fact that he was willing to do that. He took his statement out of context to what I actually said.
Did he offer to do the inspection at 1 o'clock rather than 10 o'clock?
He asked that. I told him that we already had the system to go at 10 o'clock, and if he could get somebody else to open it up, that would be appreciated.
Could you describe the system?
I had attorneys that were going to be on site. I had a contractor with equipment that was supposed to be on site. I had a locksmith that was to be on site, and I had inspection staff there on site to be able to conduct this at 10 o'clock.
Okay, thank you.
Do you have a further question?
I think I'm about through. Thank you.
Vice Chair Farmer?
Yeah, I'm looking here. I'm looking here at the information that pertains to complaints from the neighbors that children were breaking into the vacant and abandoned subject property, and that the subject property was infested with raccoons. Who knows whether they were raccoons? And was there ever any complaints from the, I keep coming back to the police department. You would think that somewhere or another, the police department would have been notified that children were actually breaking into this building.
We had reports of, several reports that we did not include of police reports responding to various activities in there. Due to the scope of the reports, they didn't detail exactly what they responded to. But from my recollection, I believe I'm trying to remember off the top of my head, but the reports that we received weren't detailed enough to substantiate exactly. Sometimes the police reports don't detail everything that they're noting, but they were called to the property site. So that's why we didn't detail or include it in an exhibit, because it would have been not substantiated one way or the other, but there were police calls to the site after during the vacancy of this property.
So the police responded and found something, particularly a transient. If they made an arrest, if they took some affirmative action, would that have generated an incident report?
I don't know, but I know that if there was a fence around there, maybe they were responding to some kind of call. I don't know what that's the problem, is without more details, I don't know what it was.
So the police never confirmed what the board member's asking?
In terms of children specifically entering the building?
Whether anybody was in the building. Children, adults.
We have no clear, concise evidence of that a public official saw that. We did do an investigation of rodents inside the building. The reason raccoons came up was the neighbors were complaining about raccoons in the neighborhood, and made the assumption that they were housing themselves in the old bowling alley building. My inspector did an investigation of that. There was some unsecured areas in the building, holes that vermin could get into. We asked Mr. Labarge at that time, and this is probably 3 or 4 years ago, to close up those openings so that we could make sure that that didn't occur.
So those could have been cats, could have been raccoons, cats, or whatever, right?
It could have been. We also have attached photos of fecal matter on the ground. Also, I believe there was a skull that was there, and I believe Mr. Stewart advised me that it was a rodent skull or some kind of skull of that nature. And it's a picture that's there as well.
number?
If you give me 1 second, I'll find it for you. As one exhibit, if you look at exhibit number 9 of the city's documentation, below the flooring, it's not the ideal picture because it's a dark floor, but that is fecal matter on the ground there. I don't know if you have a color photo of it now or not.
Yeah, we do.
And-
You gave us one.
Okay, and there is another photo.
In the restroom.
There's another one. If you go to exhibit number 25, in the upper right where the spotlight is kind of shining, or the camera light is shining, that is a skull. And along with that, that's fecal matter from animal droppings.
So, how do you think these animals got in this?
I'm going to defer to Mr.
Yeah.
Stewart on that question.
Through the door? I mean, or was there any other entrance, or?
I don't know the exact date, but I do know that my associate Larry Bean was out there on site with Mr. Labar's, found some openings where rodents get into, and asked him to close those up.
So animal control was never called, or?
No.
Nothing?
Because we did not see any evidence at the time that Mr. Bean was out there, that there was a animal running around. But there was, as you can see, there was evidence of that at some point, and so we asked him to close those up.
Were those openings closed in response to the request?
My understanding is yes.
I'm sorry, to follow up that point, just as an exhibit, if you look at 20, since you're close to it, 27 and 28, there's openings on the, 27 has a mechanical area. That's the HVAC system on top of the roof that has an opening. And then on exhibit 28, there's also, the bottom picture is of the roof, and that has an opening as well, in addition to the door being ajar that we saw photos of before.
Dale, do you have any comments?
I have a lot of thoughts, but most of my questions have been answered. The issue about the fence, yeah, they didn't take down the fence, but I certainly understand why they didn't. We know that there's been, apparently has been some human habitation in it. I think I asked you that the last time we were here, and you said that it appeared to you that in the last 2 years there had not been. Am I correct?
I said that I'd never seen any evidence of any human habitation.
Right. And so animals apparently can get into the building. It's not in good repair. But most of the questions in my mind have been done. Thank you.
Mr. Ulrich?
Nothing further at this time.
Mr. Rosenblatt?
Just, if I may clarify, have the parties rested their cases?
Can I have a few more minutes?
Oh, absolutely.
Didn't mean to rest. I'm almost done.
Okay,
I want to
proceed.
spend 2 minutes tops on this vacant building ordinance and put it to
I'm
rest.
sorry, I can't hear you.
I want to spend 2 minutes on this vacant building ordinance and be done with that subject. And there's one other substantive area I need to address, which will be very brief, and then I want a very brief closing. Okay. This vacant building ordinance has been thrust to the front and center of this proceeding, and I've fielded dozens of questions today and on Wednesday. The appeal was issued pursuant to the vacant building ordinance originally back in January, and I agree with Mr. Rosenblatt that application is not entirely clear, but what I disagree about is why that lack of clarity arose in the first place and whose fault it is. So with my 2 minutes, and this is in the materials, all of these articles are printed in full, but you know, we've got a quote from City Manager Robert Clark, dated November 3rd, 2015. And to be clear, this is not talking about the city of Ojai in general. This is a newspaper article. It's attached as Exhibit 7 about this building, this bowling alley. Okay, quote, "The city is in the process of enforcing the city's vacant building ordinance, which involves inspecting vacant properties to ensure they are safe and well-maintained." And we've got a quote from the Mayor Severo, dated November 5th. This is in Ventura County. Oh, no, I'm sorry. This was November 3rd was Ventura County Star. November 5th was Ojai Valley News. Mayor of the city of Ojai. And we're not talking about the city's actions in general. We're talking about this property, this bowling alley. Mayor of the city of Ojai. We are in the process of implementing the vacant building ordinance. Okay? And the notice and order, although admittedly there is confusion about application of the procedural requirements of the VBO, expressly alleges violation and sort of this catch-all, bring the property up to current standards, maintain the property in current standards, expressly in the VBO. So it's not, we didn't pull VBO out of a hat. I mean, the property owner was receiving mixed messages about which tool in the toolbox the city was proceeding under. And these quotes and the contents of the order itself were reason for her to think that the VBO was not totally out of thin air, that there was a connection between the VBO and this action, because the city officials were saying so expressly, publicly. It's a long day. The last substantive area I need to address, is Mr. Baker, and I wish that I had instructed him to appear to defend himself here, but the city continues to undermine his credibility. Civil engineers are allowed to practice structural engineering, okay? That's allowed. That's not only allowed, that's what they do a lot of times. And he testified on Wednesday. This is offer of proof territory. To the best I can recall, he testified Wednesday that he's been practicing structural engineering for 25 years, and and with very limited exceptions, buildings over 6 feet, 6 stories, and so forth. That is normal and commonplace and entirely legal. So he is qualified. He, in fact, is the only engineer who did any inspection whatsoever with respect to this property. Now, today, Mr. Stewart said there's no evidence of this, there's no evidence of that. He didn't do this other kind of test, and there's other areas that he didn't consider. But this, in deliberation, this board should keep in mind who is the defendant here and who has the burden of proof here. The only technical evidence relating to this property is that the property is structurally sound. There is specific, very specific information with respect to the percentage of the roof that was water damaged. It's something like 3%. Very specific information with respect to the stress levels of the 2x12 and 2x14 beams. They are within the law. Could more be done? Of course, the city has not undertaken to do that. And if they're gonna make allegations that the roof is that the building is a ticking time bomb, I mean, whose burden is it to prove the building is a ticking time bomb? Is it my client's burden to prove the building's not a ticking time bomb? You know, we did the best we could on limited information and very conflicting information to engage an engineer who put his name out and put his name on the line, his reputation on the line, and come to an opinion. So if it's limited, then it's a limited opinion, and if it's qualified, it's a qualified opinion. Of course, it's not a full-blown assessment of the property. Notably, absent is any evidence whatsoever to the contrary. So I want you to keep that in mind. And as for the building falling down onto neighboring property, I think he said that some of the stucco, superficial stucco on the property, there was a possibility of it falling within 8 feet of the property line or something to that effect. And I circle back, and this is a good segue into closing. Because Mr. Lowe closed on a point that I agree with, which is, we've spent a lot of time in the trees in the last 2 days, and I want you to think about what the forest is. I mean, look at the big picture and look at what we're trying to do here. We do not deny, it is undisputed that this property is not in conformity with the law would require of a current building erected today would be. If there are legitimate concerns with the property, then she's not hiding. I mean, she has invested hundreds of thousands of dollars already, and she will continue to do whatever the law requires to maintain the property in conformity with what a vacant and unoccupied building is required to look like. But this appeal is not it's funny to say, and it's not completely accurate, but the physical condition of the property is almost irrelevant to the appeal. I mean, this appeal is an appeal to the process by which this action has been prosecuted against my client. It's difficult to find a rule they didn't violate. If you find that this order was properly issued under the Health and Safety Code, and this building is a dwelling used for human habitation, and she has 10 days to break ground and 30 days to complete work to bring this property into such a condition that I could move my grandma in there in 30 days, well, there are further appellate options in the law too. And, I don't like ultimatums. We want resolution, and we don't want to be bogged down in courts. We've been doing everything we can to keep it out of court. And it's by Gail's good graces that we're not in court already, to be honest. We are going to meet with the city. We are going to come to a resolution, and we are going to do what it takes to bring this property into conformity with the law. But you have an order in front of you. The order was issued in express violation of the law, of state law, of Ojai municipal law. And we request that you acknowledge that that the order does not comply with the processes that Ojai has put into place.
Mr. Rosenblatt, I want to make sure I get this process correct. Should the board uphold the appeal, the city can file under a different section of the toolbox the two areas you've stated that are available under the commercial building, file a new notice and order, and that starts this time clock rolling forward. And I would like some specificity, the 10-day, the 30-day. What is the 90-day deadline within these orders we've been talking about? We've got the 10, we've got the 30. Where is the 90? Because I don't believe...
The 90 is the VBO.
The 90 is the VBO, and this would be refiled under the VBO? Okay, so...
Just inquire
not
before,
necessarily.
I'd like to answer your question,
Yes.
but are you done?
Yes, unless there are further questions.
Okay, are you done?
Yes.
Okay. The building official has several tools. Briefly, the Dangerous Building Code provides a mechanism to issue a notice and order. The California Building Code, as it's in effect in Ojai, allows for the issuance of an order, and that's what I believe Mr. Stewart confirmed. The Fire Code also has provisions for notice and order, as does the Housing Code. But putting aside the Housing Code, because that's the Uniform Housing Code, not the State Housing Code, it's not the State Housing Law. So let's put that aside. The short answer is yes. There are tools that the city can invoke to bring this matter, to issue an order and address the concerns it has in this building.
And if it were issued under the VBO, then the first three
Well,
remedies would apply under the VBO, or do they only apply under the state?
the city would need to decide which set of laws it's invoking. It would look at the facts of the case. It would evaluate the pros and cons of each remedy. It would develop a strategy on which remedy is best suited to address the problems that it has. So it would be free to invoke Chapter 915 in the future if it wanted to do that. You could go on under Chapter 1, Title 9, and focus on what is referred to as a city building code, which includes the building code, the fire code, the mechanical code, the plumbing code, the electrical code, the energy code. It has an abundance of codes under Title 9, Chapter 1 that it can invoke here. But the real question, if I may suggest,
Please.
the threshold question for the board is whether the state housing law applies. Now, Mr. Lowe contends that the board does not have the authority to even entertain that question. And I respectfully submit that whether facts were present that entitled Mr. Stewart to invoke 17980.6 of the state housing law is a question of fact. So if you decide that you have the authority to determine if the state housing law was properly invoked or not, then the next question would be whether it was invoked properly in this case against this building. If the answer is no, then the notice and order fails because it's before you solely because of one provision, the state housing law, 17980.6. If that doesn't apply, everything else must fail.
Thank you. Mr. Farmer, you've got a question?
Yeah, I just have one question for Mr. Labar. When the abatement order was issued in October of 2014, I believe sometime then, can you tell me who was the landscaping company taking care of the outside?
Severo Lara,
Our mayor, our ex-mayor.
yes.
So he was on the city council at that time? That's right. Yeah, he was on the city
yes.
council. Thank you.
Okay, do we have any more deliberation? Does the board want to make a recommendation? Does the board want to make a motion? Does the board want to make a motion and then we can discuss it? What's the pleasure of the board?
I'll make a motion.
Is your mic?
Excuse me. Thank you, Chair Daddy. Yeah, I will make a motion, and as a precursor to the motion, I have to say that I have found fault with both sides in this set two that we have here. I think that the appellant has clearly indicated that there are conditions from 2014 that have not been abated, namely the fence. That there are other conditions, however, that have been found from time to time, and we've heard about them, about random inspections and such, and when bad conditions were found, they were corrected, like closing up the critter holes, if you will, that kind of thing. I also have concluded, one, the state housing code is not applicable here. This is not a dwelling of any sort except illegally, and it's not even been proven to my satisfaction that illegal habitation has taken place here. If there was bedding found on November 2nd, no photographs of it were taken. And so I'm not at the point of saying a pox on both your houses, but my feeling is the best solution at this point would be to uphold the appeal and invite the city to reinspect and issue whatever notice and order that it feels appropriate at this point. So my motion would be to uphold the appeal, period, because the city can do whatever it wants after that.
I'll second your motion.
Okay, so, Sherry, do we need a roll call for this? No. We're going to need to discuss. Mr. Ulrich, your thoughts? Mike, please.
It's not,
Microphone.
it's not, Mr. Rosenblatt, since your narrowing qualification for our deliberation being subject to Health and Safety Code 17980, I noticed that this notice in order to repair or abate makes reference to an other applicable law. So since the notice in order to repair or abate was issued pursuant to a particular code section, does that render it narrowed exclusively to that section?
I believe I do. I believe that's the case because the notice in order, I think, on the last page is very specific and very clear that it is based solely on 17980.6. I believe that if...
That paragraph in the middle?
Yes, it's very expressed there.
Order is separate from the
And quite, let me add to that. I believe that the owner would have a right to appeal an order that is based on different codes. That's a due process issue.
Thank you. Mr. Ulrich, any more?
At this point, I agree. I concur with Member Quillisi. Yes, thank you. Member Quillisi's assessment that everybody's got mud on their boots in this one. And it would be my urgent and sincere hope that resolution could be achieved without the necessity of enforcement going forward.
Or litigation.
I would say from my perspective that I believe that while the city's case has been is supported, it also has substantial defects in it that, to me, render at question this process. And when there are that many issues outstanding, questions outstanding, and procedural challenges outstanding, I believe that since it's inherent on the city to do things in a way that's very clear, very supportable by both law and common sense, that the outcome would be evident. And at this point, I'd have to say, and I recognize that there were decisions made by a variety of players on the part and actors on the part of the city and the city's attorneys. Notwithstanding that, I believe that this is not an absolutely clear case. And as such, the appellant has substantially indicated such.
Ms. Hanson?
I more or less agree with what Bill just said. There's some shortcomings on both sides. But in the hopes that we can move this along, I would just hope that we can reach a decision today, and I agree with the motion.
Okay. Okay, I'll make my statement now. I'm going to ask for a modification of your motion, and I'll let you put it in your words. I'll just express it. We have a blighted building by acknowledgement and we have some issues that are outside of our VBO, such as the fence, what I would do is I would ask for a modification of the order that, or it doesn't have to be a modification, it would be just an amendment to the motion, or it can be just a simple referral to the motion, which is the appeal would prevail, and that the city would refile under the VBO.
Chair.
Which,
Chair
can we
Daddy,
do that?
May I respectfully
Sure.
chime in here? The board is a quasi-judicial body, and what the city does in terms of enforcing its codes is within, if we draw an analogy, that's the executive branch of the city.
Got it.
Council passes codes, city manager, building official, all other officials enforce codes. This body is just deciding the issues before it.
I call for a vote on the motion.
Motion made by Board Member Quillisi and seconded by Vice Chair Farmer to grant the appeal and overturn the notice in order to abate. Board Member Ulrich?
Yes.
Hanson? Vice Chair Farmer?
Yes.
Chair Daddy?
Yes.
Board Member Quillisi?
Yes.
Motion passes.
May I inquire of the board, could you please make a specific finding to support that decision? The finding being that you don't believe, is your decision based on a finding that you've...
As a
the board has
precursor to the
concluded that
motion,
this-
I stated I do not believe that the state housing code applies in this case. Is that the sort of finding that you're talking about?
Yes, that supports the decision to grant the appeal and
Okay.
overturn the notice and order.
Well, then I will further move to have the board find that the state housing code does not apply in this case.
Specifically, health and safety goals.
179XX.
17980.6.
17980.6 of the state housing code does not apply.
Should we take a vote on that?
Yeah.
I'll second his motion.
Are we ready for a vote, Chair?
Do we need any further statement as to what doesn't comply? Do we need, is that sufficient? Is that explanation sufficient? Because I have, I can add to that explanation if necessary.
You could find that the notice and order is based on 17980.6 of the state housing law, which is part of the California Health and Safety Code. And based on the facts presented to the board and the evidence and what you've considered in the briefs and everything else, you conclude that that statute does not apply to this building, as it is not a place of habitation or however Board Member Quisili described it.
Steve, you want to restate that?
All right, restate the motion that the board finds that state housing code section 17980.6 does not apply in the case of this building insofar as the testimony and evidence presented to the board over these past 2 days.
That is not a habitational dwelling.
And I'll second your motion again.
Roll call?
Ulrich?
Yes.
Hanson? Farmer?
Yes.
Daddy?
Yes.
Quillisi?
Yes.
Motion passes.
Meeting's adjourned. Sorry?
I have one very brief housekeeping matter. In advance of the hearing, we received some policies and procedures governing the hearing, which said specifically that the videotape recording was not going to be broadcast. I've come to learn that it was broadcast over the weekend, and whichever way it's going to be, I just want to make sure if the instructions were in error and it must be broadcast, so be it. If the instructions are accurate and the videotape was not to be broadcast, my client requested it be taken down and that today's session also not be broadcast.
Well, was it broadcast?
Yes, it was the first, yes, today was broadcast.
And we don't have,
And you're making a request for privacy that it be taken down?
I just,
saying no. She's saying no, Becker.
Okay, so.
never mind. I apologize, I withdraw. Never mind.
Okay, is there any other business? We're adjourned.